like to bring to order the June 13th meeting of the Tiverton Town Council. Please stand for the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Mrs. Mello. I'm awfully loud.
Councilor Souza, Councilor Perry, Councilor Lambert, Councilor DeMedeiros,
Present.
Councilor Shabbat, present. Councilor Pelletier, and Councilor Mello, all present.
First agenda item is Tiverton Town Council sitting as the Charter Monitoring and Complaint Review Board. Citizens complaint of charter violation section 1218, use of town resources to influence a voting contest. Before we start, I review with the lawyer how this is going to go this evening. An open statement will be made by Mrs. Driggs, who is the complainant, and then by Attorney Tremblay, who's representing the library. After that, Mrs. Driggs will be allowed to present witnesses. The council will be allowed to ask questions of these witnesses if they feel they need to. Then the attorney for the other side will present his witnesses, and same will go. If the council has questions for those witnesses, they will ask. After that, according to the charter, this is a public hearing. So I will open the public hearing, get comments from the audience, then we'll close the public hearing and the council will deliberate. At that point, no one else is allowed to make comments. So I'll go forward now with Mrs. Driggs.
Madam President, do you consider the complainants in this action to be witnesses so that we can ask them questions?
Yes.
Okay.
Is that correct, Attorney DeSisto?
That is correct, yes.
Okay, thank you.
I don't,
You have to press the button.
it's on now? Oh, it's on. Well, this may be a bit of a surprise, but I am going to open tonight with a motion to continue. And the reason I am one of the complainants, and I know that we have a right to have it heard within 30 days of filing. However, one of my chief witnesses is Mr. Jeff Caron, and Barbara Donnelly from the library will be another witness. Right now, there's an APRA request pending, filed by Mr. Caron on July, hold on. It was filed on June 1, and the original request was supposed to, hopefully, for the documents, was supposed to come in 10 business days later, which would have been tomorrow. Mr. Caron received a certified letter on Friday, or yesterday, I believe. Anyway, it was a request, a 20-day business day request from Barbara Donnelly, and it's all spelled out in this motion. And my reason for the continuance is, frankly, primarily one of judicial efficiency as you consider the complaint, because a lot of the information in the APRA request would be very relevant to the town council's task in this job. And it seems to me it would be very duplicative for me to call somebody like Mrs. Donnelly and then find that the APRA request has either made the questions irrelevant or unnecessary, or it can go either way. So here's my motion, and I don't know if you want to, how you
Please give it to the clerk.
I have copies.
Now I'll wait till you come back to the microphone. Now you are the complainant.
I am one of the complainants.
And Mrs. Cook is the other complainant.
Correct.
The APRA request did not come from either of you.
It did not.
Okay. Attorney DeSisto, do you have an opinion on this?
Well, two things. The first thing is that the charter says that you're supposed to have a hearing, and this is section 1211, subsection A1. It's actually the numbering is a little bit off. But the hearing is supposed to be held no later than 30 days from the date on which the charges were filed. So I do think you need to go forward with something today. Secondly, the next question is, and I'm wondering if this was the question that Mr. Lambert posed. The question is, on what basis was the complaint filed if an APRA request was subsequently put in after that by one of the witnesses? So I do think some questioning is in order. I do think the hearing needs to go forward tonight because of the language in the town charter. Subsection B1, I beg your pardon.
And I kind of agree that this complaint was made before Jeffrey's APRA request. So you did feel that you had sufficient information before you filed the complaint, I would hope.
Correct.
So,
But my concern is that the information, I think there's going to be vital and relevant information that comes as a result of the APRA request, which may alter. I guess my concern here, and correct me if I'm wrong, my understanding here in the hearing before the town council is that witnesses can give testimony, but they're not under oath, and there's no power to subpoena anybody, whereas the town council under the 407-7 investigation has those powers. So it's sort of going to be a question of people talking, but they're not under oath. And if something comes out in the APRA request, then I think that might change what happened here, and that's my question for the town council. And I guess my other question for DeSisto, does it not count that the hearing opened and that a continuance was asked for, that a hearing has in fact begun?
I have a question before you answer that. Don't you feel that you had vital and relevant information before you filed this request?
I didn't file the request.
No, I'm sorry. This complaint. Don't you feel
Yes,
that?
yeah.
Obviously you do.
Yes.
Because you did file the complaint.
Yes.
So your APRA request, I don't understand why that would be relevant right now, because
Well, can
we
I
need
just-
to hear why you filed the request.
I'll be glad to tell you why I filed the request. Could I also just advise that I have attached the APRA request to the motion you now have in front of you, as well as Mrs. Donnelly's extension for an extension. And I think you can read the kinds of information, especially paragraphs 1 through 4, that have been requested.
Attorney DeSisto, would you like to answer Mrs. Driggs' question?
Well, I think just the mere motion to the continuance doesn't constitute it. If I could make a suggestion, start on with the hearing, hear what the witnesses have to say, and I think you can determine whether or not this is something that's necessary to make a determination as the hearing progresses.
Would any of the counselors like to weigh in?
I would if I could. And I think I would favor postponing to a later meeting because I'd like to see the information requested. We need to know, I'd like to know who paid for the sign. I'd like to know if it was paid for with proceeds of the library, and if any of the printing was done by the library. I'd like all that information because it's not the first time that, it's not a major crime, but we're sitting here, and the only way we can really determine what actually happened is if we have all of the information available, and I think this request will bring that to us.
Madam President, while I may not disagree with the comments made by Counsel Mr. Souza, there's absolutely no reason at all why the two people who filed the complaint can't, on their own personal knowledge, make an opening statement and offer testimony. Whether or not there'll be a need for a continuance, we can make a decision on that later. But, as you know, Mrs. Driggs, most trials take 4, 5, 6, 7, 8, 9 days. They're continued day after day after day, and that's exactly what we can do here today.
Would any other counselor like to make a comment?
Yeah, just an observation. on the APRA request appear as though they would have little bearing on the testimony provided by Jeff Karen, in so much as they would on any testimony provided by the library. These are all email messages or communications or records to be produced by the library staff. So I don't see why we can't at least start moving this process along.
Anyone else?
Okay.
So at this point, I will go on unless somebody would like to make a motion to continue the hearing.
I'll make a motion to not continue and to have this heard tonight.
Do I have a second?
Second.
I don't really know if I need a motion to
Yeah, I don't think
continue.
you need a motion.
I
That's-
need a motion to not
Not
continue, so
Just with-
no one wants to
That's a not-
make that
Because
motion.
I'll make a motion to continue.
Do I have a second?
Second. The motion not to continue, I'll make the second to that
No,
motion.
no, no,
To continue, no, I'm not making a, seconding that.
Joe just made a motion, if I'm not to understand, to continue this hearing to a further date. Is that correct, Councilor Souza? Do I have a second to that motion? Motion fails, so we will continue. Mrs. Driggs?
Thank you.
Madam President, at this point, I'd like to make at least ask a question, and at least in part at this point, it's a procedural issue. According to the complaint, you've cited section 1211, which indicates that subsection A, that any qualified elector of the town may file a sworn statement with the complaint set forth. I don't have a sworn statement.
If I could address that, and I'll be glad to, I actually, when we filed the complaint, I said, don't we have to sign something? And we were told no.
And Council Lambert, I did look into this. All the other complaints that we have heard in the last couple of years, no one has done a sworn statement. The charter does say that a sworn statement is necessary, but past practice up to this point, all the charter complaints that we've heard, no one has done a sworn
And
statement.
can I just
And
clarify?
as far as my issue is concerned, I consider it to be irrelevant. The issue may not have been raised. The charter here could not be more specific, and that is that there be a sworn statement. It's at least my understanding that you and Mrs. Cook filed this complaint together. You're an attorney.
What, that, could I clarify?
You're licensed as an attorney.
Can I
You would
clarify?
know what the definition is of a
I obviously know what the definition. I would like to clarify. When we went in the week before to figure out how to do this, Donna and I went. That's when I asked, and don't we need some kind of a sworn statement? The day that it was filed, I had signed it, you are correct, but I did not actually go to file it, only Mrs. Cook did, because I had another appointment. So I was not there. You'd have to talk to Mrs. Cook whether anyone said to her anything about a sworn complaint, but my guess is they didn't, and she is not an attorney. And
You don't know that for sure, then?
I don't know that.
Because you
You
weren't
can
there.
ask-
point
Mrs.
I
Cook
have-
is right here.
I have no sworn statement.
Nobody
And that's
said
what I'm
anything to me
requesting-
about
and
that.
that's what I'm requesting under the charter.
Attorney
Can I ask the
system.
attorney, can we, I'm sorry.
The complaint was not handed to me. I was in a meeting at the time. It was handed into the clerk. However, I will concur that we have, on any of the other charter complaints, taken the signature on it as,
And I will further add that.
That's not my point, Mrs. Driggs.
I
as you
understand
know.
your point.
You can waive, as an attorney, you know you can waive a sworn statement. I am not waiving the sworn statement.
I understand that. I understand your point. What I am trying to get across is this, nobody said to do this to the person who actually did the literal filing the day it happened, who was not an attorney. And furthermore, as I understand it, the first threshold is that this has to go through the town clerk, who makes sure that everything is in order before it gets to you. So it obviously passed through that threshold. So I think to now hold us to a standard that is different than any other complaint that has gone through this town clerk is not correct.
And I will end with this. I recognize that a sworn statement, the requirement of a sworn statement, whether in a criminal matter or before a town council, can be waived. What I am saying is that there is a specific provision in the charter that requires a sworn statement. And as a trier of fact in this case, I am asking where the sworn statement is.
That I'm asking for an accommodation, if the town council is going to take that position tonight, that since nobody raised it till we got here, and I'll ask the attorney, is there any way that right now we can sign a sworn statement that this was our complaint and we did in fact file it?
Attorney DeSisto.
Well, actually, one of the things I think the council has to take into account, obviously this hasn't been sworn when it was filed, but the plain fact of the matter is that it did come to the council after the town clerk determined that it was sufficiently set forth. I think you can cure it right now if you just want to have a notarized statement coming in so that this thing can proceed, rather than having a dismissal here and then just a refiling and the process going forward. It seems to me that the hearing has started, and then it should proceed on that basis, however you want to cure that, or if there's a waiver by the rest of the council. I think Councilman Lambert is correct. That requirement can be waived. He's made it clear that he himself will not waive that. So I think there's some things that can happen here in order for this hearing to proceed.
Madam President, I'll make the motion to waive the sworn statement.
Do I have a second?
I'll second.
Motion's been made and seconded to waive the sworn statement. Any discussion from the council?
Why is this an issue if we have a complainant that's willing to make a sworn statement right now?
Because Councilor
Okay.
Lambert brought it as an issue.
Oh, yeah, the resolution could potentially be that they provide a sworn statement right here.
Well, that also could be a motion. Councilor Souza made one motion. So motion's been made and second. Any further discussion?
Just to say that it's been stated that it was forwarded to us, all right? And in the past, we haven't asked for sworn statements, so just common practice. Going forward in the future, maybe the clerk should require that. Maybe it should be somewhere in so that people know when they're coming in.
Motion's been made and second. Any further discussion? All those in favor? 4. Against? 3. We're going to go forward again.
Nancy doesn't know who voted for what.
For Nancy would be Councilor Souza, Councilor Mello, myself, and Councilor Shabbat. Against would be the other 3. Continue, Mrs. Driggs.
Thank you. So the basis of the complaint is that, well, actually, I'm not sure the procedure. I've made a packet of exhibits for all of you that I'm going to show. Do you all have a copy of the complaint with attached exhibits? You do? Oh, okay. But would you like the ones I've already made? Does it have pictures attached to it?
Are they better quality than what we have?
No. They're exactly the same. All right, so
I'm sorry, I keep forgetting to put on the mic. I guess briefly I need for you to summarize this for the
that's what I'm
audience.
going to do,
also
but
for us.
it was going to make it easier. So in your package, you will see as one of the pictures, I have it marked as, well, it's a letter. There's one packet in your thing that looks like this, and I think you can read it. So it came to our attention that attached letter was in the Tiverton Library general area, and this was on or about, I would say, May 14th or 15th that somebody first noticed this letter in the general area, next to budgets that were already out on the table, which nobody's contesting that. There was a copy of the different budgets, but then there was this letter. And secondly, it then appeared, this same letter, around May 17th, was noticed sitting in a plastic stand, which is actually the picture you have in your book. And that picture was taken by Mr. Karen, who's here to testify. And it was out in the children's library room on the table. There also were signs that were, so this letter was one issue. I guess I'll call it a letter or a flyer. There also were signs that said, vote budget number 1, and then a line, save our library. And there were 2 of those signs on the property of the Tiverton Public Library, and there was one of those signs. It was not the same shape. It was more a triangle sort of, well, it's a picture of that in front of the Union Library, which is always out in front of the Union Library with various messages on it. But in the week before, at least probably a week before the election, May 21st, FTR, that sign had also vote budget 1, save our libraries, and I think something else it said. So that's the gist of the complaint, that the library, the director, the board of trustees, who, you know, if you look at the flow chart, the board of trustees are appointed by the town council. They hire the director. And these clearly, it's our contention, we're in violation, we're a 1218 violation, using town property to advocate a particular budget. And what isn't clear, and we can ask, we have no idea where the money came from for the signs. Obviously, the Tiverton Library gets a significant grant, as we all know, from the town, and that was one of the issues. And I think we all need to remember, in particular, that this particular budget year for the library was a critical one, because there were 3 budgets proposed, and the budget committee, budget number 1, even though it didn't give the library the $600,000 they requested, it did give them, I think it was $556,500. Budget number 2 was an unknown to the library, because that was the budget which did in fact win, as we all know, that would demand a remand. And they were not sure how they would fare in a remand when that line item was revisited. And budget number 3, which was Councilman Souza's budget, actually reduced the library to $500,000. So the library took a position, obviously, that they would hope that the known amount of what they would get in budget 1 was what they wanted. And it was a very, as people remember, a passionate election this year, and there was a lot of issues flying back and forth and statements being made. But that being said, it's our position, and that's the basis of the charter complaint, that not only did they violate the use of town property with the signs in the flyer, but potentially a violation of the use of grant money in any of these things that went on. And that's something you have to determine whether that happened. But I think I frankly, I don't know what the issue is, because the signs are here and you have pictures of them. So that's the gist of my complaint. I can tell you, if I am also a witness, I guess. I am the one. I live on Peaceful Way, which is just a little bit south of Tiverton Four Corners. So I drive back and forth on Main Road all the time. And I'm the one who did take the picture that you see. On May 18th, I took that picture of the sign in front of Union Library. Mr. Karen took the signs on the property of Tiverton Public Library. He took the sign in the children's room. And Mr. Katz will testify that when he went in there on, I think it was May 17th, there was some woman standing in the children's room. He noticed the flyer next to the budgets. And then there was a woman standing in the library wearing like a placard that had the sign on it. So those are the issues.
We don't have a picture of that, though.
Yes, actually, the last, it's very blurry, but the last,
That's
but just,
probably what
it's this one, and you can just, that's the picture just showing that it was in the children's room. But the next picture after that has a picture, you can barely make it out, but there is a person with a sign that wearing Budget One. So that's the gist of our complaint, and I don't know how you want me to proceed.
Clarification on that.
Yes, I'm sorry.
The woman, this is very blurry, but is it a patron, or you said it's just some woman? Was it a?
It's right.
I have no
Did you
idea.
see this picture? This is her. It's in back of there. I don't recognize her, but how would I with this?
Well, I don't think the issue is
No,
whether.
right.
Yeah, whether
So we
she's,
don't
Nancy, you're talking about this one?
Yeah.
yeah.
Okay. It looks like she's holding it with her hand, but,
Well,
okay.
Mr. Katz is present, and
Okay.
I don't know how you want me to proceed. I
Yeah.
mean, do I call these people up and ask them questions, or do they just testify as to
You,
what they saw?
You will after Attorney Tremley does his opening statement, and
sorry.
what we'll do is have you call them up and you can question them,
Okay.
okay? Thank you, Mrs. Drigg.
Madam President, before you
Madam
move,
President, before that, do we have any questions that we can address to the complainant?
Yes.
Madam President, I have a question for the solicitor. Is it legal to take pictures of people in a public building, in a library?
Yes.
It is? Without them signing off?
Not,
In the children's room,
In the children's room?
with children there?
it depends on if the pictures of the children were taken.
There were no pictures of children.
Madam President, I did have a couple of questions. I wanted to just clarify a couple of issues. Section 1218, under the heading of use of town resources, and that's it's under that provision that you filed this complaint. It says that no officer or employee shall use, cause to be used, blah, blah, blah. Could you identify which officers and employees you're aware of that were at the library at the time?
Well, that were at the library at the time it was going on?
No, I want the name of
The
the officer.
director is Ann Grealish-Rust. She's the director of the Tiverton Public Library, and she was there. I only know from, I have not talked to Mrs. Donnelly, but I know from a Newport Daily News article that she indicated that she was aware that she saw a sign on the Tiverton property and didn't think, it just didn't really register. But then she made a statement that the director knew nothing of it, and I have no idea the basis for that question. But my feeling is, if you have a director of a library, and that's one of the questions I will ask, I would think the director is responsible for under the policy of the library, for anything that is displayed in that library.
Do you consider this, Mrs. Briggs, to be a criminal matter, or is this simply a civil violation?
I think, well, it's definitely a violation of the charter, and
Right.
that's up to you in terms of
But
whether you.
You know that the rules are different for criminal matters and civil violations. For example, ignorance is no defense in a criminal case. Ignorance is a defense in civil litigation.
Can I just tell you that this same criminal complaint was filed by Mrs. Cook when we had the school, let me just finish, please, when there was the school button issue that she filed with school things being passed out in the school, and at that time, Mr. Roderick was on the town council.
So-
Mr. Roderick is
But
now on the board of trustees of the library.
My question specifically to you is, do you consider
No, wait a minute. I don't see the relevance of that, though.
There was a whole discussion during that hearing. I'm not accusing Mr. Roderick of anything.
Well, he
Well,
looks
I
like
am
you.
using your name in this, I'm using your name in the sense that one of the issues that was before the town council at that time was whether people had to know what was going on.
My point, well, that they should have known. And I think
There's
that's the
inferred
issue that I'm
knowledge.
trying to get to.
There's inferred
And you've
knowledge.
already, In a criminal matter, there's inferred knowledge?
No, I'm
Is
not
that your
talking about
understanding?
criminal matter.
Okay.
I'm
Do you
talking, this
consider
isn't a
this to be a
civil,
criminal matter, or is it a civil?
it's a civil matter.
Civil matter.
It's a 1218 violation.
Now, you indicate no officer or employee, section 1218 indicates no officer or employee shall use or cause to be used town property, goods, money, grants, etc. All I'm asking for is, can you identify for me the officers or employee who you have knowledge, knew that the letter was being placed there and the signs were being placed there?
That's to be determined.
No,
I cannot identify.
No, it's not to be determined by me. You're the one that's filed the complaint.
No, it's to be determined by, yes, it is to be determined by you after you hear the evidence and the witnesses. I cannot tell you who was there. That's for you to ask to find out, because that's a very important question.
It is. And you indicated in the complaint that was filed here that you were most disturbed to see the attached letter. Did you go to one of the officers? Did you go to one of the employees when you were most disturbed seeing that letter?
No, I was disturbed when I got a picture of this letter and added it to the complaint.
And that's not what you say here, though. That's not what you say in the complaint. On May 17th, it came to our attention that the attached letter was in the Tiverton Library General area, and most disturbing, it was on a stand. Okay, so the letter was disturbing to you.
The letter was disturbing, and the fact that
And
it
I
was on a
assume it was
stand,
as far as
that's
you
why
know,
we filed the
And as
complaint.
far as you know, it was disturbing to Mrs. Cook.
Yeah, she can speak for herself. She's
But
right here.
at this time, for purposes of section 1218, you are not able, you yourself, whether there's other witnesses we'll see, but you yourself, you're not able to tell me whether an officer or who the officer or employee was who was involved in
No,
placing that
I
letter
cannot
there.
tell you that. That's for you to determine.
Can you tell me who the officer or employee was who directed the placement of the signs?
No, I cannot.
Okay.
Thank you,
That's
Mrs.
for you to
No further
determine.
questions. Thank you.
Any other questions for Mrs. Driggs? Thank you. Attorney Tremley.
Thank you. Good evening. I'm here for the Board of Trustees of the library. A couple of things. As far as a sworn statement goes, I realize that can be waived. However, I think the right to waive it is against the person the charge is brought. We don't even know who the charge is brought. You're sitting as a charter complaint review board. In order to have a complaint against an officer or an employee, you need to identify somebody. I don't think, as representative of the Board of Trustees, we will waive the right to a sworn complaint. But furthermore, I would like to attention to 1218, which says, no officer or employee of the town. I don't think anybody's alleging the trustees or employees of the town, because they're volunteers. So I guess they're alleging they're officers of the town, under the town charter. Well, I would ask you to look at the town charter over and over and over again. It identifies every office and officer in town. There is no mention of the library trustees. The library trustees do not come under the town charter. The library trustees exist by Rhode Island General Laws, Title 29, Chapter 4. And that is why they're not in your town charter. So they can't be officers of the town subject to the charter if they're not subject to the charter. You appoint them as trustees, not under the charter. If you look at the charter, you have no authority to appoint the trustees. Your authority comes under Title 29, Chapter 4, 5 of the General Assembly, which says that you can appoint them. But that's all you can do. You can't tell them to charge for a book. You can't tell them to pay a bill. It's set out by state law. They are not under the town. They are a part of the state as a free library, and your only involvement with them is two. Number one is a funding provision in there. There's another provision that they have to approve bills and the town treasurer would pay them. But as far as if you can identify them as being an officer of the town, you're not going to find it in your charter. And because of that, you can't sit here as a charter complaint board and say they violated the charter that they're not part of.
So you're saying Excuse me, you're saying the Board of Trustees is responsible for this letter and placing it in the library?
No, I'm saying that the Board of Trustees can't be brought before this Charter Review Board under 1218 because they're not officers of the town of Tiverton.
But, no. Any questions? Peter?
A question to our solicitor. Is the building itself town property? Would that fall into the charter complaint?
Well, the building itself is owned by the town, so it's town property.
So under that, the charter complaint could be still going forward?
The building, yeah.
The
Well,
issue,
but the placement of
Right.
the information within that building is a town-owned property. I just want to clarify.
But if,
Madam-
Wait a minute.
if I may,
No, I'm asking our solicitor.
No, I'm not. Tony?
the building itself is town property, and if I understand the complaint correctly, the town property that was used unlawfully in this would be the town library building, if I'm reading it correctly. That's part one. What Mr. Tremblay is saying is that in order for this to proceed, or for there to be a valid complaint, the public official, a public official or a public employee needs to be identified, but I would direct everyone's attention to section 211. A2, because that does identify that any elected or appointed official or member of any board or commission, or that any official body, board, or commission in its corporate capacity, or any town employee has knowingly taken any action or failed to take any action in their official capacity that violates the terms of the charter. So I do think that that's the operative language in the charter, although I will say that Mr. Tremblay is correct, that public libraries in the state are governed by state law and not by any charter or ordinance provisions. However, there are town employees there, and the building is a town building.
Can I ask a follow-up question on that for some clarification, Tony?
Yes.
I'm sort of just thinking out loud here, but if your claim is that 1218 indicates that any elected or appointed official or any member of a board or commission or any official body, board or commission in its corporate capacity or employee, blah, 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 in A2 of 1211, that seems to me that I'm not sure how you can get from that to applying 1218 to people outside of the purview of the town, or rather outside of the specific recitation of language in 1218. Do you know what I mean? Like, so 1218 is more defined. It's an officer or employee of the town. That is all that 1218 applies to. So theoretically, if you say, someone not mentioned in that section, how can that apply to them? Because they wouldn't be in violation if the section didn't apply to them.
You've identified an internal conflict in this charter between the two sections, because you're correct. Section 1218 is more limited in scope than section 1211A2.
No, see, I don't think I have. I think I've outlined something that is maybe clunky, but not necessarily inconsistent or mutually exclusive. What my argument is that 1211A2 is clear. It says all of these people, none of these people can willfully violate a term or provision of the charter. But what I'm saying is 1218 specifically says this section of the charter pertains only to officers or employees of the town. So if I were neither of those people, but fell into the more broad definition of 1211A2, it doesn't matter if any of these things have happened, I am not subject to that authority. Does that make sense?
I agree with that statement. You have
All right, I just want to make sure
If
that,
this were a Venn diagram, 1218 would be the smaller circle, and 1211A2 would be the larger circle. And it's not, the two don't, that to me is the discrepancy.
Mr. DeSesto, Madam President, I don't agree that there's an inconsistency. Section 1211 merely refers to who a qualified candidate can make a complaint against. Well, obviously, they have to make a broad statement because it reads, complaints by citizens. Any qualified elector of the town may file a sworn statement in the office of the town clerk charging that. And then it tries to catch everybody who could conceivably be mentioned in the charter. 1218 couldn't be any more clear and any more specific. And I might point out that Section 1218 was enacted well after Section 1211. So there was an opportunity to take a look at the earlier language. And yet, Section 1218 is limited to an officer or employee. Based on that, in order to have a violation of 1218, we need an officer or employee.
If
The specific provision, I think you'd agree with me, Mrs. Griggs, always overrules a broader, ambiguous. Okay, well,
This is Attorney Trembley's open statement. Yeah, I know you respect that.
I think I heard her say town property. If I went to sign on a town property, I wouldn't be here, because I'm not a town officer or a town employee in 1218. The trustees are not town officers or town employees. They're statutory employees under a state statute. Your only function is by state law that allows you to appoint them.
and there is a potential, at least a potential penalty for violation of Section 1218.
There is.
And that's perhaps the reason why it's so specific in limiting the application to an officer or employee and doesn't drag in by reference all of the appointed and elected and members of boards and commissions and blah, blah, and official boards of commissions in their corporate capacity, blah, blah, blah. It doesn't try to bring in that broad, general language. And typically in any type of situation where you have a penalty that could be addressed, you have to follow the specific identification of the potential violators. And that, in this case, 1218 couldn't be any more specific, officer or employee.
I have nothing further to say.
That's what I was just going to ask. Thank you.
At this time.
Mrs. Driggs?
If I could just briefly respond to two things that appear, I don't know if it'll be helpful in the conversation we just had, but on the Tiverton, the official website of the Tiverton, Rhode Island, under Library Board of Trustees, it says the Town Council appoints the Library Board of Trustees. The board consists of 7 members who meet monthly on the first Wednesday of each month. They serve a 3-year term. The board is responsible for hiring the director, setting policies, advocating for full services, and securing operating funds. The other thing that appears on is a flow chart that is on Tiverton Library Services organization flow chart, and I have one for each of you. And it clearly indicates a chain of town administrator, town council picks the Tiverton Library Board of Trustees. They pick the director who's in charge of, this was when Essex was there, Essex and Union. So I'll be glad to pass these out. And
If I may, what she has just cited are the provisions of Title 29, Chapter 4, Rhode Island General Laws, and not the town charter. Everything she said is correct. We are not employees of the town. Everything she said is contained in Rhode Island General Laws 29.4 as trustees, not officers. Trustees under a state law, not officers of a town of Tiverton.
Then I will also indicate, as a member of the Budget Committee, I'm well aware of the fact that every year the library comes before us for grant money, and Tiverton grant money is pays the employees of the Tiverton Public Library.
And I would cite for you the provision she just read was Rhode Island General Laws 2947, not the town charter.
Question, Madam President.
I also have a question.
Go ahead, Councilor Souza.
For the solicitor, I'm just thinking back, it's quite a few years ago, we had a legal battle in town, and it was determined that the employees at the library are not in-town employees. And it's, furthermore, I guess we don't bargain their contracts. It's done by the trustees. So that's where I'm still confused, and I asked this question the other day, and I'm hearing two sides here, but you're saying that, well, would you re-explain who would be, I see, I'm confused, because this complaint, who exactly is this complaint directed at? Is it the trustees or the employees who aren't employees of the town?
But my question was,
I'm directing it. Is that me?
I think it's Tony.
Oh.
No?
Can't have a lot of things on,
Oh.
like one at a time.
I am. Oh, okay. Thank you. I'm directing it at the Board of Directors of the library, Board of Trustees of the library, and the Director of the library. And I guess my broader question is, if the library itself, everybody acknowledges is public town property. So if you can't, if you don't hold the Board of Trustees, and you're saying nobody is an employee of the town, then anybody can put anything out on that property because there's nobody to bring a complaint against? That just doesn't even make sense.
My answer was to that, Mrs. Dries, would have been, is it just possible that Section 1218 is very poorly written? Is that possible?
That's,
Yeah. Because what you've just said is you're directing, and in your opening statement, you indicated you were directing your attention to the Board of Directors trustees. You said Board of Directors trustees.
Board of Trustees.
Just want to use your language. The Board of Trustees, at least to my understanding, are not they're not an officer and they're not an employee of the town.
there are a lot, well, I also want to just respond, there are a lot of board members in town who do it on a volunteer basis. They don't get paid, so if that's the standard you're using as to whether they're an employee, but their flow chart shows that they are appointed by the town council.
But your complaint is directed to the Board of Trustees. I can define that, I can identify what the Board of Trustees consists of.
And the director, director.
Well, you added on director.
I think when you
At this
asked, I
point.
said both.
But starting with the Board of Trustees, just that title, does that make them an officer or employee of the town?
It makes them a board.
But there's nothing about a board under Section 1218. That's my problem. What you're doing in order to get a board in is you're going to Section 1211, which is the more general specification, which indicates any qualified elector of the town may file a sworn statement in the office of the town clerk charging that. And then it goes on to list just about anyone that you could identify that's connected with the town. But that's not what Section 1218 says.
Attorney DeSisto, would you like to add anything? Joe did direct the question to you, I
Well,
understand.
if I could, the second part of it was, if funds were used, library funds were used to pay for the sign and the printing for the pamphlets. Do we really have, since we give them a grant, do we really have it, does the charter apply to that portion where, town funds would have been used for the purpose of promoting that budget? Being as we give them a grant, and I know we don't have any say in how they spend the money.
Well, under 1218, and I do think that Councilman Lambert's made some good points, you need to take a look at, before you even get to that question, if an officer or an employee of the town runs afoul of the complaint that's been filed. So I think that's the first thing you need to identify. To answer your first question, I'm not sure who issues the checks for library employees.
The town,
The town?
Well, through their grant.
which comes from the town, from the taxpayers.
Okay. Well, to me, that makes them town employees.
Madam
We-
President,
We
Madam
handle
President,
the payroll for them. That's,
No, we pay for it. The taxpayers pay for the grant.
Madam President, I'm also going to object to the fact that we're extending the complaint. Even if this is a civil complaint, a party is entitled to know what he's being charged with. In paragraph 1, you indicate specifically what your complaint is. And I'm trying to find in paragraph 1 any complaint that there was a misuse of funds with respect to the purchase of the letters, the correspondence, the printouts, whatever.
I do
We-
not
we-
have that information. That's what the APRA request
but
will tell you. We
Then-
do
then
not
we
know
should-
that.
Then we shouldn't even be considering it tonight.
You
You're-
can ask questions of the director. You know that signs were placed. I don't it's not my job to investigate. It's
But
your
you
job to
haven't, no,
investigate.
you haven't made a specific complaint that there was a misuse of the funds. I don't know that, and apparently you don't know
I
that, and
don't
you're
know
making the
that.
complaint.
No, I don't know that. I don't know that. So I can't say there wasn't.
But my point is, as a matter of due process, even if you have nothing more than a civil complaint, the party that you're directing the complaint to has a right to know what you're complaining about. And in
I
this
am
case,
complaining-
somewhere you should have indicated or suggested that somehow there was a misuse of funds, misuse of grant money in the purchase of the signs, and the purchase of the letters, and the printing of the letters,
I have
whatever.
no idea who paid for the signs, who paid for the letters. But I do know that the signs and the letters were on town property, and I think it's the town council's job at this hearing, which was passed on to you now, to investigate. My guess is you have people from the Board of Trustees and the library here, and you can ask them.
You're going again beyond the issue that I was trying to address. I'm not
under-
suggesting somebody didn't put him into the ground. What I'm saying is the complaint that you're making here is there's been a misuse of funds. Nowhere in paragraph 1, which is your complaint, do you even suggest that there was a misuse of funds. And all I'm saying is that as a matter of due process, whoever you're directing this complaint to has the right to know what your complaint is.
No, that's the section. I think it's something that they don't appear from nowhere. So somewhere they appeared, and somebody delivered them, and somebody got them from somewhere, and these are all questions that can be asked. And I think if it turns out that these signs appeared because the library employees bought them with their own money, that's one thing. If it turns out that they were supplied, or grant money was used to put them there, that's another.
They don't even have to provide you with an answer.
We
You
can-
haven't
we
made
can
that
ask the-
part of your complaint. That's my issue. It is not part of your complaint. Why should they address something that isn't part of your complaint?
this
Fine.
complaint here.
I understand what he's saying. So can we move forward to the signs? That is part of our complaint. And they are public employees who put signs on the property.
Wait 1 second. Councilor
Potentially.
Pelletier.
Yeah, I had a couple of questions about a half an hour ago, so I'm just going to go through a couple of them. And I guess I'm a little confused because initially when because A sworn statement would have cleared this up. The original complaint doesn't specify the board of directors, I mean the trustees rather, nor does it specify the director of library services.
And that's where I get back to my answer, and I will say the same to you. You obviously can't sue a building. It passed through Mrs. Mello's desk to you, so she found sufficient facts to pass it on. And
She makes no determination
I
of
understand,
facts.
well, she makes determination whether there's sufficient to pass it on to you.
She makes a
And-
determination that the complaint is complete.
Correct,
Okay.
correct.
Well, there you go. Well, let's go home then. Nancy took care of it. What I guess my issue is, no, I'm sorry, that was, I guess my issue is, it seems a little bit like you have witnessed something, the result of something, right? The existence of materials. You don't know how they got there. You don't know who put them there. You don't know who paid for them, where funds came from. And if you did, you didn't tell anyone. And I don't think, I mean, if we're the first backstop of saying that whether or not this complaint is valid or not, it seems as though that there has been no identification of individuals or a body or anything more specific than a lowercase recitation of library.
Okay, can I ask
You
you
can.
all a question, please?
You can ask me a question.
I can ask
suppose.
you a question.
I can't answer for them.
Okay. So, we filed a complaint, we have pictures, and people will testify to the exact date those pictures were taken, in a week before the financial meeting. If they're on town property, clearly I don't think anyone's disputing the fact that they're on town property. And you're basically saying, because we haven't done a complete investigation, which I don't think that's our job, I think that's your job to do at this hearing, to ask, I would think you, the town council, would be sufficiently concerned if this kind of activity were going on before an election, on town property, advocating for a particular budget, that you would want to proceed with talking to the other witnesses who are here and calling them forward, which you have the ability to do. Short of that, frankly, I would think you would, just from what you've seen in these pictures, as a body, you might be compelled to hold your own 4077 investigation where you can get all this information and subpoena witnesses and have them under oath and find out what's going on with town property before an election.
All of that being said, I don't necessarily agree or disagree. I don't think the existence of those facts or anything else alleviates the responsibility under 1218 for compliance with the provisions of the charter complaint. If you're going to say someone or something violated a specific provision of the charter, then you must qualify those violations and the people and individuals and bodies that were involved. I mean, I don't understand why that's not plainly obvious. Because you said you don't know if anyone involved in the library put them there or not. Do you know if anyone on this stage put them there or not?
I don't know who put them there, but
So
I
why
can
isn't
have
the
people
why
testify
isn't the
that they
complaint
saw
against
them there
every
in
elector
the
or employee
library.
of the town of Tiverton or every member of a board of commission or every
Because
person
the
that is
library has a director who is an employee and is paid by the town. The director, I believe, is,
So that's another question I have.
No, no.
What?
nothing.
Okay. Is the threshold in your argument, is there a threshold that because it's a grant, the funds that are used cannot be used subject to 1218?
Correct.
It is also because they receive a paycheck from the town of Tiverton, whether they are administered by we do their payroll for a convenience, or whether they are technically employees of the town.
We say they're employees. They get 2% pay raise like everybody else. Yeah, was that a question?
Yes, it was.
Oh, I'm sorry. Yes.
Okay. So I guess taking that logic, you could then say that anyone that receives a grant from the town of Tiverton, those people that are paid from that grant under your argument are also employees of the town of Tiverton?
If it's paid in salary, this is,
Okay,
salaries come out of this grant.
Sure.
Isn't
So
that what
salaries
makes
come
an
out of all
employee?
grants, one would argue. If you want to think about, say, the Women's Resource Center and the YMCA, all these other places that we give grants to. Whether they're large or small, I think, is irrelevant. But is your argument also that those people who would be paid, even if it is one fraction of 1/100th of 1% of that grant, are employees of the town of
I'm not
Tiverton
even
and
going
s-
to,
and are subject?
I'm not going to take that position. We're dealing with the library. And let's just get on with it. Here's the point. We have the, no.
I'm trying to
I'm
conduct
try-
an investigation. I mean,
Well,
I'm
then-
trying to
well, then
understand your
call
argument.
Mrs. Donnelly up.
Okay. The last thing I will ask is of Tony, the question about, Attorney Tremblay has made the assertion that this complaint cannot apply to the Board of Trustees because they are not employees of the town of Tiverton, nor is it, are they officers of the town of Tiverton. Is there any, can you opine on that one way or the other?
Mr. Trombley is correct that the Board of Trustees are, their authority and their enabling comes from the state statute. He's correct with that. They are not listed in the charter. He is correct on that. However, they are appointed by the town council.
Now,
You need to draw a conclusion from that. You can't just say they are appointed by the town council. What does that mean?
Well, I have to say I don't agree that they're not connected to the town of Tiverton.
But are they officers or employees?
I would consider them officers.
Okay.
I would.
now, Attorney DeSisto, the director of the library, she's paid from a grant. And she's issued a grant from the treasurer because we do their payroll for them. Is she an employee of Tiverton?
Is she paid by the town?
She's paid out of the grant money,
Which comes from the town.
but which is given to the library to do what they have control over that grant. Am I correct? Attorney DeSisto, you with me?
Yes, I am.
I can't see you. So, is she an employee of the town? That's my question.
Do you mind if I hold for a second? I just want to ask Matt a question.
Sure.
First.
Madam President, well, if I could, very quickly, the lawsuit that I was talking about years back where the employees of the library tried to unionize, it went to court. It was deemed that they are not town employees and they could not unionize. We give them a grant, and pretty much it's spent as they see fit. None of the employees of the library are town employees technically.
No, because we don't hire them. This is the way that we don't hire them, and we can't fire them. So are they our employees? That's my question. The Board of Trustees hires them, selects them, I would imagine does evaluations yearly on them, and they are in control of that employee. Am I correct?
You know, I have to tell you, I know it's a grant, but it's coming from the town of Tiverton. The money is coming from the taxpayers, and they're getting paid with town of Tiverton checks. And, you know, to me, if somebody gets sued out there, the town is going to be defending. It's not going to be a separate operation at all. I don't consider the director or the employees over there to be non-town of Tiverton employees. However, I see the town treasurer here. You might want to ask her how the method of payment is and everything else, because
She's been dying to answer this question. Come on, Denise. We need you to weigh in on this.
Okay. We receive payroll and invoices from the library that are approved by the Board of Directors, and we pay those as a convenience to the library. And that's how it's been done for, I don't actually know how many years.
can I ask a quick question? So in other words, you yourself don't consider the employees at the library to be town employees?
Well, I would have to agree with what Councilor DiMadeira said. We can't hire them, we can't fire them.
Okay. May I ask Mr. Tremblay a question?
Are you all set with me?
Thank you. Tremblay, sorry.
Yeah.
If the library gets sued, who defends? The library or the town?
Well, I don't know the answer to that question, but I'm sure there's some insurance running around that covers them. But can I answer your question another
Yes.
way? Everything that you attribute to them as being employees is spelled out chapter by chapter by chapter in Title 29. It says that the library will hire the director. They will submit the money to the town. They approve the bill, and the town pays the bill out of the grant. I looked at this charter 3,000 times. I found every commission, every board, everything that functions as part of the town government in that charter. I don't see a thing about the library. And the reason that you don't see a thing about the library is because the only function the town has with the library is an appropriation, which they can control, the library can, and they can appoint the trustees. And they only can appoint the trustees nowhere in this charter. They can only appoint them under Title 29, Chapter 4. To be very honest with you, I'm not going to waive any of my clients' rights here tonight. I'm not going to allow a fishing expedition of the Board of Trustees. I can tell you that no library funds were used for any signs. That can be verified through the town treasurer. That can be verified by looking at records. But we're not going to have a witch hunt. I mean, what if I put those signs up? I'm not coming before you as a charter review committee because I'm not subject to your charter. And I'm not going to allow you to subject people who are not subject to it to have to defend themselves in front of the board. I will tell you, quite frankly, you can make any decision you want, but I'm not going to allow my clients to make statements in front of a board that doesn't have jurisdiction to hear it because if some citizen decides to make a fishing expedition without having the courtesy of swearing to a report. You swear to a report, so you're not the guy in the bleachers yelling, "Hey, you bum." You swear to the report because you stand up and say, "I think I'm right and I'm willing to stand behind my word." You can say you can waive the sworn report. Well, you want to waive any other word in the charter? The answer is no. Only I can waive the sworn report if I'm the target of the charter violation, and I don't even know that. Thank you.
Tony?
I mean, can I also ask this too? When we've done this in the past, when the town clerk was the subject of a charter complaint and members of the school, they had appointed representation in the form of the town solicitor, whether it was the school committee's attorney or the school department's attorney or our in-house attorney, and we hired special counsel to advise us. It doesn't seem like the library shares in that protection. I mean, they were advised by us to hire outside counsel. That's not a practice we have done in the past when members of boards of commissions or employees of the town are subject to inquiry or any other legal proceeding.
Well, you've heard from the town treasurer as to how she characterizes the employees over there. You've heard from Mr. Tremblay, and you've also heard from Mrs. Driggs. This is a predicate question. So I think you need to make a finding of fact as to whether or not those employees of the library are employees such that they fall under the provisions of Section 1218. I don't know how much more information you could get other than what you've heard from the treasurer, other than what you've heard from the attorney for the library and Mrs. Driggs, in my own opinion. But I do think it's something you need to make a finding of fact on as a predicate question.
And your opinion is they are employees of the town?
Well, I've got to tell you, I'm not as firm as I was after listening to Denise. You know, the question to me always comes down to what happens if there's a lawsuit and who is going to defend that. It seems unclear to me at this point. I think Brett raised a good point over the fact that there's private counsel here. You've heard from Denise, but I do think a finding of fact needs to be made. My only concern on this is that I know it's a grant, but it's town funds. and they are getting paid through the town of Tiverton. My question is if there is a lawsuit, who is going to defend on this? Depending on how you go, it may mean that the library has to defend on employee claims as opposed to the town.
The last thing I'll say about the grant thing is, in the years past when we've had this conversation, we've had it a number of times about what the status of the library is, there have been just as many people on the other side saying the grant is just that. It's a grant. They spend it the way they want to spend it. It is no longer town funds once you give it to someone else. You know, I don't know that we're ever going to resolve this with any permanently, but that's, I recall hearing that. I mean, the argument has always been that they get a grant and it is issued as a grant, and therefore money cannot be taken out of that account after the fact. It would be essentially trying to claw back something you've already given to someone, whether or not on paper, in an accounting ledger somewhere, it stays as a charge account because we do their bill, a lot of their bill paying for certain invoices and payroll.
Actually, I don't know how relevant this is, but I do know, to what you just said, there is an ability to get a waiver from OLIS for the state aid if the town is unable to match what they matched before. I don't know if that plays in at all, but...
Yeah, I guess what the conversation we had in the past was actually after the fact. If we gave, say, $600,000 and it was approved, ordinarily, say, the pension fund or something, you know, the day after the account settles, we write a check so that it's gone, it goes into the account. Whereas this, we actually sort of on paper hold on to it, or portions of it, so that when they have invoices that we process for them, including payroll, we charge it against that account. But I think the argument would be difficult to make to say at the end of June, we could transfer money out of that account.
No, you can't.
I think that would
So
be...
here's my question for the town council. A complaint's been filed. You're now telling me, I think, well, maybe you haven't definitively stated yet, but make your decision and then I'll address it.
Tony, my next question, the complaint also about the sign being on town property. Is that can the Board of Trustees put a sign on the library's property promoting a budget? It's town property. Because that is another part of this complaint.
But you have to be an employee
That there's a sign that we're
or an
not...
official. So that depends how you define them.
No, despite whether or not they're employees of this town or they work for this town property had a sign placed there. That's a violation, correct? Well, not a violation, but that is town property where there was a sign promoting a budget.
But this...
So can any private citizen that's not under our control just place a sign?
Well, I'm looking at the case in re Joseph A. Cross, 617 A. 2nd, 97. That's a Rhode Island Supreme Court 1992 case. And one of the statements is a public library is a public forum only when those activities that are consistent with the nature of a library. The First Amendment protects those consistent activities. So I do think that there are some First Amendment implications here if a private person uses that public forum for the purpose of free speech when it comes to an election.
So I guess the question is whether or not the Board of Trustees are employees and the director is an employee of the town, and that's what you feel we need to determine before we move forward.
Yes, you need some findings of fact on that, because under Section 1218, which is the section that is alleged to have been violated, that's what it is, no officer or employee. So you may have to make that determination before you can proceed on to the next question.
Okay, and how do you propose we do that? By just...
Well, I think you need some discussion, but whoever makes the motion would need to make some findings of fact on that issue as to whether or not the director, those employees, even the board, are officers of employees of the town. And you have the factors. I don't think there's anything else that you can take a look at over here. The town treasurer told you that it's done as a matter of convenience. You know how the budgeting is. You know where the money's coming from. It's in the form of a grant, as Councilman Pelletier has pointed out. You've heard from me, Mr. Tremblay. We have different opinions on this, as well as Mrs. Driggs. So I think that whatever the motion is, you should base it on those factors in a determination as to whether or not these employees are in fact employees of the town.
So based on the facts that we've heard here tonight.
Madam President, I'd like to make one point then. We've been arguing here, it seems forever, with everyone having their own opinion as to whether or not someone can be an officer or employee. This is a civil violation. It means that ignorance of the law, in fact, is a valid defense. We haven't even reached that issue. We haven't discussed it. But if we're talking about nothing more than a civil violation, and we're arguing the issue, and you have attorneys arguing the issue, it seems to me that the Board of Trustees will have assuming that they're an officer or an employee, that they're going to have a perfectly valid argument to make, gee, we didn't know that there was a violation. If somebody had just told us, Mrs. Driggs, and you asked me, you were asking, I guess, the panel here, what else could you have done? In all honesty, here's what I would have done. If I had been most disturbed, as you say you were, I would have went to somebody in the library and said, oh, by the way, I don't want to cause any problems, any trouble here, but, and I don't want to drag the town council into this, but I'd like you to take a look at the charter. And I think it's possible, because I'm mostly disturbed by this, that you're in violation of a section of the charter. Do you think somebody could see about getting the signs and the letter removed?
I didn't say,
Don't you honestly believe
asking
that
a
something
question?
that something would have been done?
Can
No,
I tell you?
no, it's
that
the answer. It's the answer to the statement that you made earlier. What else could I have done? Well, I'm telling you what else you
I
could
didn't
have
say
done.
what else could I have done. I am telling you that the person who saw those signs and took the picture was on May 17th. We filed this Donna filed this on May 18th, and on May 18th, let me finish, please.
Yeah.
On May 18th, when they went back to the library, guess what was gone? The flyers
But did somebody?
Guess what was gone?
Well, I'll
The
tell you what
flyers in the
I'll tell you
children's
what I would have done. Then I would have gone up to somebody and said, "Gee, I just happen to be a retired lawyer, and let me tell you. Let me point to a provision here in the charter.
wasn't
You
the
may be
one.
in violation of this. Why don't you make life
Excuse
easier
me,
for everybody
Mr.
and just
Lambert.
remove the letter and
Mr.
remove the
Lambert,
sign?"
I don't appreciate your argumentativeness. I was not the one who saw those flyers. The person who did see them, both people who saw them, are present, and once you make your determination whether Section 1218 applies to the library people, which you guys haven't done yet, but if you decide it doesn't apply, I hope you understand the ramifications, that public property of library is going to be covered with political signs in the next election.
Well, maybe the next time someone sees a violation like this, Mrs. Driggs, instead of being dragged here for the evening, you'd have the courtesy to go up there and tell them, you may be in violation of
You
the
are
charter.
being rude.
Because what I'm raising is
Madam
the issue
President, I
of
object.
ignorance is a defense.
Madam President, he's badgering her.
And no one has established to my satisfaction that anybody
Come on,
at the
Jay.
library
Come on, Jay.
knowingly violated a charter provision.
All right, everyone stop. Joe. Yeah.
Yeah. God.
I'm sorry. It's kind of the pot calling the kettle black. But we'll go on. I think we have no more argument. Let's try to handle this in a professional manner. I think the first determination was someone would like to make a motion on whether or not they feel that the Board of Trustees is an employee of this town.
Could I, before you make that, I need to ask Tony one
Go
more
right ahead.
time. What is your opinion regarding them as an employee? I want his one more time to explain
Okay,
that.
talk to Tony.
So Tony, besides that, I want to know, is the director, you said she wasn't, how about the employees within the library? Are they employees of the town?
I'm going on what the town treasurer said, and that the payroll is being handled as a matter of convenience, and that she herself does not consider these employees to be town of Tiverton employees, notwithstanding the fact that they're getting paid from the town.
Thank you. And is Matt around? Could we ask Matt's opinion, or is that irrelevant?
Matt's in the middle of something right now.
I think it's important. So.
It is.
While he's waiting, can I ask a question of Tony?
Yes, go ahead.
The question I'm still stuck on is whether or not, I think before we even get to whether or not this person and this entity are either employees or officers of the town, what seems to bother me the most is that neither one of those entities or groups or people is specified in this complaint. How do we get around that? And I think it matters. It should matter. You shouldn't just be able to say everybody is subject to this until I can pick which ones I want. I mean, it's supposed to be specified in the complaint.
That's the notice requirement that Mr. Tremblay has brought up. His opening statement basically was, we don't know who is the target of this complaint because it just says the library. That's his point. You haven't gotten to that yet. It seems to me that the focus has been on whether or not the employees, the director, and the board are even subject to this type of a complaint under Section 1218. That's a separate issue.
I think that's secondary to the fact, I mean, I guess we get there after we determine whether or not the complaint is valid, because I just have a hard time. I mean, we only found out who actually was specifically named after a number of minutes of opening statements and questioning. So if that is the case, and this can evolve into whatever, or do we make a finding that these are the people that are only these people and this body is subject to this particular complaint? I don't know if you ask them to redraft the complaint or you just add it in there or what, but I don't.
I think it's preferable to reach the predicate question first.
Because without the first question answered, there is no second question. We don't care if those two entities are, you know what I mean?
That's correct, yes.
Okay.
So, I'm sorry, I would like to hear from Matt, his opinion as well, regarding these employees. Does he think that the department head of the library is an employee of the town? Or any of it, not the board of trustees, but just the employees?
Well, I think the question I asked, Matt, do you do their evaluation?
No,
Do you determine whether or not they get raises?
no.
And if there's any disciplinary matter, who handles it? Not you.
If there's any disciplinary matter at the library, it is the responsibility of the director of the library.
And how about if the director is the disciplinary problem, who handles that? Has the problem against her?
If you
Would
were
it
to
be-
ask me, I would say the board of trustees would be responsible for the director's performance.
So would you say that any of the library employees are your employees then?
No,
Or
I don't evaluate, I don't appoint, I don't. We've had
You don't hire?
We've had discipline recently. It was all handled by the library's director, reporting to the trustees.
And you do not hire any of their employees?
No,
And it does not go through the personnel board of the town?
correct.
That's an important one.
What was that?
It doesn't go through the personnel board,
Okay.
the board of director.
So, one more question then, Matt. They don't require to have a personnel manual from the town of Tiverton, right, the employees?
That manual was not extended to the library.
All right, thank you.
Madam President, I hope it's the last comment so we can move on. And I don't want to rehash what we've already said, but Joe and myself were on the Budget Committee for many years. And as Mr. Karen would say, I was the chair for 3 years. We hashed this issue out for all the years. We have no authority over the library, none whatsoever. We just give them a grant, and they're on their own. We don't do the hiring, we don't do the firing, we can't tell them where to spend their money, we can't tell them anything.
The one
They're
issue,
on their own.
the one question I have, also, I know the attorney Trombley, Trombley? Yes. Thank you. He mentioned that it's the creature of the state that makes it possible for our town council to appoint the board. But the point, and Attorney DeSisto, I'd be interested, the point is, our town council does appoint the board of directors, board of trustees for the library. Wait a minute, and then when you look at the flow chart, it's the board of trustees who are then responsible for the director. So somewhere there's some responsibility for the town council for what goes on at that library, even at the highest level of appointing the board of trustees.
We appoint all boards, Mrs. Driggs. There isn't one board that
But
we
you're
don't
saying
appoint.
that this is not a town, you're trying to have it both ways.
We're not
But
trying to
see,
have it both ways.
what I would like to say is we appoint all the boards and the commissions. And Matt is in charge of the boards and commissions, but not the library. Is that correct, Matt?
I think that's absolutely correct.
The town council is not in charge. Matt is in charge of all these, except for the board of trustees.
Madam President, the distinction I would make is that we appoint boards. I agree with Mrs. Driggs. But we appoint those boards under the charter. In this case, we appoint not under the charter. There's nothing that addresses this issue under the charter. We do so only at the direction of the state legislature by state statute.
If I may, to answer the question that was presented, 2945 determines the appointment of Board of Trustees for all cities and towns and states, and they invest that in the cities and town councils. If you want to know your limitation on power under this chapter, they had passed a special act, 2949, allowing the town council in East Providence to name libraries. I mean, it's totally separate.
Can I ask Attorney Trombley while you're here, because I think it's important, after the town council appoints them under this section, do they have, what if a board of director is not performing, they have no other...
There's
How
all
do they
kinds of
appoint
avenues
them?
to address issues. The issue that you chose is to bring it in front of the board as a charter review,
No.
and they're not subject to the charter. I don't know if
Okay.
you know.
All right, I don't think
I'm
there
just
should be
asking,
a lot of
does
this
the board of-
dialogue going on.
Does the town council have the ability, after they appoint them, to
What?
discipline them, to remove them, to do anything like
No,
that?
they do not.
All right. Would anyone like to make a motion to determine whether the board of trustees is an employee of this town?
I second
I'll make a motion
Wait a
that they're
minute.
not an employee of the town.
And you
An
have,
officer or an official is not an employee of this town.
and what I understood from Attorney DeSisto is you have to name the facts why you're stating this. So it would be,
What? The state law, number one, was
Okay.
2495. And if you look at section 1218, it actually says, Jay's, it's quite clear.
I think you could also mention that we do not pay them from,
And they're not on any payroll of the town, absolutely.
and we cannot discipline any of them also. Do I have a second?
Second.
Is that appropriate, Tony?
I do think that you should, the motion should also rely on the testimony that you got from the town treasurer as well as the town administrator as to their status of as employees for the town as opposed to the library.
Would you like to amend your motion to state that also?
I'll recommend the motion to state that also, yes.
Conversation?
I have a second.
Yes, you have a
Do you
second.
second the amendment, Jay?
Yep.
Okay. The
Only that,
amended motion. Go ahead, Joe.
We had talked about a continuation, and I'm still in favor of continuation to allow Mrs. Drigg and Ms. Cook to, continue their research and come back to us with a little more evidence. And I'd like to see the request of, was put in by Mr. Karen to have a little more information on what exactly happened, because the signs and the pamphlets were put there. And whether we can afford, whether we can hold somebody accountable under our charter or not, there was a failure there. Well, the failure started when, we need to know what happened so that in the future, when we do charter review, we can correct this situation. Because, as Ms. Driggs pointed out, I mean, if what I'm understanding, I could have put a budget 3 sign out there, and nobody could have said boo. Or would I be subject to a charter complaint? I don't, it's, if, there has to be some accountability. That's a town building that we're paying for, and there should be some accountability in the charter.
May I just briefly respond? What Mr. Souza is saying is that if someone comes forward and names Joe Schmo as possibly the person who put the signs into the ground, all of this hearing that we've just had this evening is for naught. That person hasn't received any due notice, hasn't received any notice, hasn't received the benefit of due process, and all of this testimony is going on while he's at home watching television, oblivious to the fact that his future is being decided.
Madam President, if I could, that's why I'm waiting for the information that Mr. Karen asked for. It could shed some light on exactly what happened.
I also did, also for point of clarification, excuse me, I did, Attorney Nancy Mello mentioned to me, Attorney DeSisto was, I think the day after the complaint was filed, that maybe the library was needed to be more specific. I said to her, fine, I would like to name the director and the board of trustees, and she said, it's already passed on, bring the issue up at the hearing.
Any further discussion, because I do have a motion on the floor.
Madam President, just to, it would be helpful to hear the motion back again. I'm sorry, I was splitting my hearing between 2 people.
Nancy, do you have the motion, or we could clarify it?
Council Perry made, seconded by Council Lambert, that the library, board of trustees or directors, not employees of the town, or officials, officers or officials under the state law, or under section 1218. They are not on the town payroll, not disciplined by the town, and Mr. DeSisto added that we would rely on the testimony of the town treasurer and the town administrator as to the status of their employment with the town. That's what I have.
Any discussion from the council right now? Any other discussion regarding the motion?
Yeah. I just want to recap, because this is my notes on it. Public libraries are governed by general law, Rhode Island General Law 29-4. The public library, the Board of Trustees are not mentioned in the town charter. The Board of Trustees receive funding from the town in the form of a grant. Once the grant is approved, the Board of Trustees have the ultimate approval authority for the payment of invoices that are paid through the town accounting department as a convenience, also per Rhode Island General Law 29-4. Section 1218 refers only to officers or employees of the town, and them using, and their use of town property, goods, money, grants, or labor to influence the outcome of an election. Section 1211, where it comes to enforcement, it seems to broaden that issue to include others. But in effect, I believe 1211 does not override 1218. 1211, Section 1211 of the Charter is to be more inclusive, to include other chapters in the Charter. So in case there's a complaint about the school department or the town council, it broadens it up to, or a commission, it broadens up the complaint. But Section 1218 is very specific that no officer or employee of the town shall use their influence to determine the outcome of an election. That being said, I believe it's correct that the Board of Trustees, the library director, or any employee that works at the libraries are not officers or employees of the town. I think it's very specific, and I have to agree with it.
I have a motion on the floor, and I have a second. All those in favor? Opposed? 6-1. Joe. So from now, Tony, am I correct that when they get further, when this party gets further information and they feel that they need to file another charter complaint with more information, that then they are free to do so?
When I, before we get to that, I think now that you've made this motion, you're going to need another motion to deny the complaint.
Okay.
Based upon your prior motion.
Do I have that motion?
So moved. Second.
Motion been made and second. Any further discussion?
Well, I'll say again, I think we should just continue until the next meeting so that we can get more information before we rush to judgment.
Any other discussion? I have a motion and a second. All those in favor? Opposed? So motion's been denied. So it's been denied, the charter complaint.
Thank you, and I just would like to,
Okay, all right, we know.
yes, please. I would just, as a point of fact, address Councilman Souza that I appreciate the sentiment, but to me, it makes it pretty clear that what has happened tonight is that there is no person attached to the library that we could name to be held accountable for anything that person might have done or not done, or even find out if they did it, because you've effectively removed any physical being from being accountable for what goes on at the library in terms of Section 1218. Thank you.
Thank you. At this point,
Something to add. May I?
At this point, I'm taking a 10-minute recess. There's an incident going on in town right now. The town administrator needs to get a briefing, and then we need to brief the council. So a 10-minute recess. Thank you. Okay. Can we please not do this? Can we please not do this? All right. All right. Everybody separate. Jeff, did you hear what I'm asking?
No, I didn't. I just got accused of something.
I would just like everyone to please, the police chief is not here right now because there's a critical situation going on in town. So could everyone please behave for 10 minutes? There is a shooting down our main road. I've had it. I've really had it with the way these people.
Unless it started in 70. That kind of makes it.
Chief Saul, which everybody on the road signed, fully in favor of. And this is what I was going to say tonight.
Okay, because we might be able to get him to take care of it even without, so we'll try. Okay, all right.
You know my phone number.
We got it all, sir.
Of course, hope everybody, I mean, it's a busy world out there.
It is.
And God knows what happened and no one knows where.
Tiverton?
But even so, it doesn't matter. You know, if two former police officers just got shot in Tiverton, then the town administrator needs to get to where he needs to get to.
No, I would agree with that.
And Jay Edwards just told Matt, you need to make statements, and if police officers are dead to him.
Yeah.
All right, so we're waiting. Matt's on the line right now.
Okay. Yeah, as soon as he gets back.
We can get enough people up there, we might be able to.
Yeah, but we need Matt. We need Matt.
If we can get enough people, we might be able to.
Yeah, there's a couple of things
Right.
here that Matt's going to have to do.
We can't because Matt's getting the information. We're going to make sure if the information we got is correct. All right.
Those days are over.
Because they said it's on patch. Shooting's on patch. Voicemail.
Yeah. Yeah, that would
They're probably trying to tell me about it.
Oh, they'll be here shortly.
Brad, I can't see. Enter cop. Did you call in?
Yeah, because we decided not to go out to this meeting because we at least don't have the agenda item.
Oh, shit, that's the damn story. What?
Yeah. I saw Peter come in. He was in the back.
I see Peter in the back.
It's allergy stuff. I'm like blind. I might as well great vehicle. I have very bad.
The blue flowered.
I have someone who's got contacts me. One's actually negative 12. I mean, I'm not done cheering. He was legally blind. He's focused. There's a lot of times you see him squeezing. He was just trying to make
Many times.
just a nutbag. So I got much better information. No, you don't understand. A lot of rooms. Spiraling out of control. Peter.
Has anyone seen Councilor Mello? Councilor Mello, I need you. He's not going to come.
What happened to him? What's he talking about? Madeline?
It's Jim Odell, he's right there. He said,
Robert Donnelly? Yeah.
Robert Donnelly.
he didn't hear anything about anybody dying.
Madeline left.
Yeah, it's right there. It's right in that house.
Shots were fired in the Fall River when they were through calm.
Mello, Peter Mello. Let's go.
Trying to have a meeting here.
They'll all vote for you, don't worry.
Just right here is good. I know there's like already more than 100,000 rooms. I can only tell you what the chief of David can tell me. An individual, there was confrontations with Patsy, a sentence cut. An individual was shot and killed at Patsy Cemetery. We don't know. The perpetrator was pursued at that point and probably was already part Fall River police chased him down Ford Farm Road. He became trapped at the dead end of the cul-de-sac. When he emerged from his vehicle, he exchanged gunfire with 3 police officers, 2 Fall River and 1 Tiverton. The perpetrator was subsequently shot. It's not being reported, but he is dead. There are 2 fatalities. No, there are no officers hurt, no officers down. So that pretty much is the end of the information. It is already in the business office. Colonel O'Donnell is coming as is Attorney General's office. This is an open, so I asked, I said, this is an open investigation. All you're going to do is guide. We're going to say 2 or 3 sentences. So there's no reason to interfere with the council's business. No need for anybody to come here. We've got a law enforcement supervisor. So if you concur with that, we can stay here.
Not our job.
I just didn't know if they needed a man up there.
No, Nancy will tell us the real story.
All right, we're going to continue the meeting. Consent agenda. Approval of regular council minute meetings of April 11th, 2016. Approval of special council meeting minutes, May 2nd, 2016. Approval of executive session minutes, council meeting, May 23rd, 2016. Approval of special council meeting, June 6, 2016. Receipt of minutes from the following boards and commissions: the Cemetery Commission, Conservation Commission 3, Recreation and Beach Commission 2, Prevention Coalition 1. Correspondence received and filed. Exeter West Greenwich Regional School District Resolution on Gun-Free Schools referred to School Department. Town of Exeter Resolution in support of Article 15 relating to municipalities of the Governor's FY 2017 budget. Susan Gill regarding Department of Health permits to sell food at town concession stands. Senior citizens regarding budget cuts to senior center. Town Administrator, Police and Fire Department overtime reports through May 2016. Solicitor zoning overlay ordinance and comprehensive plan language regarding proposed casino referred to Planning Board for recommendation. Bay Street area moratorium, vote on extension of moratorium to December 31st, 2016. Town Administrator, notification of reappointment of Donald J. Medeiros to Building Code Board of Appeals. Town Administrator Department monthly reports for May 2016. Treasurer Denise Charette, budget and revenue reports for May 2016. Councilor Pelletier, distribution for discussion and possible action at the next meeting. Town Council long-range goals. Town Council governance policy. Archer Harmon, 44, Gilly Hill, traffic on Gilly Hill referred to police chief. Would any of the council like to pull anything from the consent agenda? With that said, I need a
I would like to pull,
that's okay.
I would like to pull CA 3C,
CA.
Susan Gills.
Oh, good. I want that one.
Anyone else?
I'd like to pull CA 3D.
Anything else?
I would just like to mention CA10 and flag for you guys maybe to take a look at that for future meetings.
So would you like to pull that?
No, just
okay.
wanted to give you a heads up on it.
Okay.
Madam President, CA 10,
CA 10.
A and B.
We'll discuss, are you pulling that?
I'd like to.
Okay. All right, I'd like to entertain a motion to approve the rest of the consent agenda.
So moved.
Second.
Motion been made in second. All those in favor? Unanimous. CA3C, Susan Gill regarding Department of Health permits to sell food at town concession stands. Councilman Mello.
Hi, I would like, if Susan would like to address the council.
Road. I'll try and keep this fairly brief after what we've just gone through. I submitted, well, actually, I'll start with a year ago on the Recreation Commission. As a group, we wanted to address the issue of food permits at the concession stands on all town properties. It was found that there had never been any permits ever pulled in order to ensure public safety and protect the town against liability issues. We felt that that was an important issue. So we didn't pursue it right at the beginning of Spring Little League. I met with the administrator and we agreed to waive that. Then starting in the summer, I went back to, 3 times I emailed the town administrator and spoke to him. I wanted this issue addressed before the fall season began. Each time I didn't get a response or an email. One time in person I asked him how this should be handled. The commission felt that they didn't want to have the position to address this, that it was the town administrator's job. He agreed to this and said he didn't want to send a memo out to them, but he would speak with both the head of Little League and soccer. Beginning in September, when the season, or end of August, the season started, the concession stands again were still open. The issue at large is not that they're selling anything, it's that they're cooking out of these concession stands. They have deep fat fryers, they're cooking chicken, they're cooking fries, and as far as I know, none of these buildings have running water. These are not my rules, these are the Rhode Island Department of Health Safety guidelines. Every food service that you know requires food handling permits, food safety managers, and we felt that the town should fall under this same practice. So I believe the town clerk was notified after a complaint was filed in September to the Department of Health. The solicitor was notified and still no action was taken. So as you know, then once I resigned, I knew this was still on the back burner, but I was not in a position to pursue this. Then when I saw the spring season start up again, concession stands were going, I knew this situation had not been addressed, and I felt that as a citizen I needed to come forward with this, that this was one thing that impacts the town, it impacts the children that are playing there, and I think it's serious enough that it had to be brought forward. So I contacted, this is about my 3rd trip down to the Department of Health. John Mullen is the person who handles Tiverton. I spoke with him again. He gave me several options to pursue. I tried to take the least difficult course of action, but when that kind of hit a dead end, I felt I had to bring it to the council. That was my responsibility as a citizen with this knowledge, and I would be negligent if I withheld that. And so here I am. This went on the agenda Wednesday. I believe by Friday, the town administrator did contact both Tiverton, or the Little League and the softball groups, is what I've been told, and that they were told to stop selling food at the concession stands until they obtained the food permits. I'm not sure if they did operate this weekend, even after they were told they were not supposed to. I would like to submit for the record, along with the letter, I didn't enclose all the attachments, but the emails that I had to the town administrator, the filings that I did to the Department of Health, so those are on the record. If the town administrator did send a letter to the sports leagues, I would request that the council obtains that for a matter of public record so we know what was said and what the expectations are. You know, this started with the commission. This is not me. It's not always me, and I'm not here to be the bad guy. My interest in all this is to protect the town for liability on the risk of any foodborne illness. You know what would happen. These are kids, and it would be very costly to the town as well as tragic, and it's also very much a safety hazard. It's parents of these kids that are playing that are doing the cooking. I'm sure very few of them, if any, have any food handling safety, and the fact that they're deep frying chicken and have no running water to clean the equipment afterwards is a little disconcerting, to say the least. And I felt like the public needs to be aware of this. I would have liked to have gone quieter channels, but it seems like sometimes this is the only way things get changed. The other thing I wanted to say was, it's not to say that they can't have any food. You know, there are the cost. Well, there is no cost as a municipality for the food permit. They just have to request annually from the Department of Health a food permit. They can sell bottled drinks. They can sell prepackaged drinks. They just can't cook. If they did apply for that and listed their menu items, there would be an inspection, and I most certainly would expect they would fail, given the conditions of the concession stands. Let's see, what else? So that's what I'm bringing forward for you tonight, mostly just to make you aware of it, to know kind of, I'm pleased that there is progress being made in this direction. Mr. Mullen, I spoke with him this afternoon, and he said he was very interested to work with the Recreation Commission and the town to get this, hopefully fixed before the fall season. The other thing I think that the council needs to be aware of, that when there are special events, I'm not sure what all category they fall under, but like the pesky tournament and the soccer tournament, these are special events. I know recently the soccer tournament had kids from 38 communities, or there were 38 teams, and they're doing a lot of cooking. These large events need to go through, food safety. They need to apply to the Department of Health for food permits, just like you would have a caterer or a food truck, to make sure that when they're on town property, they are, following the laws of Rhode Island Department of Health. I just want to say they're not my laws, they're the Department of Health's laws. And so anyway, I'd like to submit, that's my speech, and I'll submit these. Nancy can make copies, I guess, if you want them for the record, and if you have any questions, I'll be glad to answer them.
I have a few questions, Ms. Gill.
Oh, sure.
They need a food handler's license, and do they need a Serve Safe license also?
If they're cooking. If they sell like bottled water, Gatorade, any bottled drinks, or prepackaged like snacks, chips, whatever, you don't need anything. But you still need to get a food permit from the
So if
Department
they're
of
serving
Health.
hamburgers and hot dogs, they need food
Right,
handlers
you would need to have a food
and
safety
Serve
man.
Safe
Right.
certification.
Right, and running
Ms.
water.
Gill, were you on the Recreation Committee last year?
Yes.
Did they serve French fries and fried chicken last year?
Yes, they did.
The year before that?
I don't know the year before. I don't believe I was on the committee. I assume they have. I was told by somebody in the community that a number of years past, they had been told to stop, and they did for a while, and they started up
So last year when you were on it, you weren't concerned, you just got concerned over it this year?
No. You can
But
see.
you were concerned
no,
last year?
My emails, it was April, well, it was March of last year. I got the information from the Department of Health. I contacted Mr. Wojak in April of 15, and it was all last summer. I was in touch with him when I was on the commission, and I got no response and no action.
Okay,
So
thank you.
I tried to do my due diligence on the commission, well, as the whole body. Is that it? Okay, thank you.
John, did you want to say something as head of the recreation?
I would like to say something.
Okay.
John Cordero, 19 Blueberry Lane. Since this came up, the state did contact me because they thought the Recreation Commission was involved in running the concession stands for the youth organizations. I explained to them that the Recreation Commission does not run concession stands, nor do we have any authority to tell anyone what they can and cannot do. I had a nice conversation with the gentleman from the state, and I agreed to act as a go-between to gather information that the state would like to see from the youth organizations, exactly what information the state needs so they can direct them in the proper handling of their food serving and get them the required certificates. Tiverton Youth Soccer only sells packaged, prepackaged, and cold beverages, prepackaged food and cold beverages. They have not even been opening their concession stand because they can't find enough volunteers. Little League has been selling hot dogs for 40 years. Nonetheless, there's requirements they need to meet. The state and the league have both told me that they are more than willing to work together to get those certificates that they need. I am awaiting an email from the state. I have a contact person for Little League, contact person for Tiverton Youth Soccer. When I receive the email from the state outlining what they would like, the information they would like, so they can direct them in the right direction, I will forward that along to those contact people in those leagues, as well as the town administrator. He was also kind enough to tell me he's going to include some ordinances that the state has, and some of the important information that the leagues can use, and that the town and the Recreation Commission can store that information. If there's a change of guard in one of the youth organizations, at least we'll have a place where the information is available to them. As far as the Recreation Commission, it was brought up, it was never voted on. It was a concern of one of our members. That member brought it up. That member was reminded that we are an advisory board. We have no authority to tell Little League, Tiverton Youth Soccer, or anyone else for that matter, what they can and cannot do. And then it was, I don't remember it coming up again. Going to the special events. There was a soccer tournament last weekend. There were 600 or 700 kids that came through. We got nothing but compliments on the facility, on the tournament, on the way it was run, on what it is for. And I would like the council to know, and any citizen who is concerned, that the person who runs my concession stand for the soccer tournament has not a food handler's license, a food manager's license. So I feel very confident that everyone ate well and ate safe. So when I get more information from the state, I'll pass that on to Claudia's contact, to the president of Tiverton Youth Soccer, and to the town administrator. So, thank you.
Thank you, John.
John, before you go, are the concession stands run by the Boosters Club for most part?
The Boosters would run the Tiverton High School's concession stand,
but not.
But Claudia's folks, it's volunteers. There's one gal I think that kind of heads it up. Now they do have 5 concession stands throughout town. They have 2 at Town Farm, 1 at Southfield, 1 at Fort Barton, 1 at Pecasset. Currently, they use a hot dog roller. The gentleman from the state said, "Oh, we're good with that. We'll show them how to do it right." I let them know that they do French fries, but they have some new type of air fryer. He was the gentleman from the state was familiar with that apparatus, and he said, "We're good with that." What they basically do for concession stands, they do it all across the state for youth organizations throughout Rhode Island. They're pretty much treated like a hot dog stand, because that's what they are. And it's running water and septic is not necessarily required for what they're doing.
I just want to make sure that I mean, I think the hot topic is if there is a deep fat fryer. Hopefully that is not the case, and if they are using those, we make sure that is not going to be a practice going forward.
Well, I believe they've been advised by authorities more powerful than I to stop selling cooked food,
which would be chicken in a deep fryer.
And I don't know that they're using any deep fryers anymore. At the concession stands. Special events, that may be a different story.
Well, that's clearly that's an indication of, or the deep fat fryer is a concern for not only food safety, but also it's incredibly flammable.
Yes, absolutely.
Especially if you use frozen
Yep.
food. So we want to make sure that practice is safer.
Yeah, we're going to work, the leagues and have already expressed that their desire to work with the state to get what they need and to be doing things properly. So, and maybe moving forward, we can look at any ordinances we may have requiring certificates and match the state. In other words, if there's a special event somewhere, someone wants to have a fundraiser over at Pecasset School, you know, if the state says, hey, a food manager can manage everyone cooking food and serving food, I would like the town's ordinances to match that. Because maybe the town might have a different ordinance where every server needs a certain permit. So I'll try to get that information from the state as well, so we can match, so we're not in conflict with each other, and so that the town's not requiring more than the state does, because I don't know if that would be necessary. I don't think that would be necessary.
And before you go, John, I just want to thank you. I know it's been a short period of time since you took over the Recreation Department, and you've done a lot of work so far, getting things going on a timely basis, so thank you.
Thanks. There's been a lot of help. The members have been scrambling to try to, you know, get the programs running, get the beaches open, and we're learning as we go. We'll do the best we can, and any help you guys can give, we're open.
Thank you.
Madam President, just real quickly, that in next year's block grant, community development block grant application, if there's some things we can do for the ball fields, I think we should put that in.
That's a good idea, Joe. Anyone else like to make a comment regarding this?
Just one comment, since this was brought up, I'd like to have like an update from the town administrator in 2 to 4 weeks' time.
Okay.
Just on where we stand.
Okay.
Thank you.
I'd like to entertain a motion to approve CA3C. Do I have a second?
Second.
Motion's been made in second. All those in favor? Unanimous. CA3D, Mrs. Chavez.
I just wanted to make sure that I'd like to thank the members of the Tiverton Senior Center and Janet Rancourt for documenting their concerns and the need to have the senior center open, and I want to just make sure that this does get to the budget committee.
I was going to suggest we forward this to the budget committee. They're meeting tomorrow. Cecil's right here. I could always give him a copy.
That being said, I'd like to make a motion to approve item CA3D.
Motion's been made in second. All those in favor? Unanimous. CA10, Councilor Pelletier, distribution for discussion and possible action in next meeting, Town Council long-range goals, and Town Council government policy.
I didn't remove it, David,
No, I know.
so I'm wondering if
Mrs.
he
Barrett.
had...
You did remove it.
I thought Mr. Pelletier would remove it, seeing how he put it in. But I'd just like some explanations on what exactly you're looking for on this.
Did you get the backup material?
Yeah, I did.
Okay.
And I read it.
Okay.
I think it's pretty.
There are 2 items. The first is long-range goals. It's outlines some it's fairly broad and broad, I guess, policy goals that I think we should probably talk about as we get closer to November. And they can be as narrow as, you know, these simple electronic good government things, trying to get people, townspeople informed and on notice of certain things, and it can be much more sweeping in a, it really is whatever. I've put together just a quick memo about sort of a simple good government access to information policy we could have going forward, but it certainly does not limit the scope of the council to, I mean, the charter authority is 4072, which is to develop publish and annually review and revise long-range goals, objectives, and strategies, including but not limited to town services, capital improvement and maintenance, equipment, and personnel and staffing. So it's pretty broad. I thought it would be to start to spark a larger conversation of what our policy objectives are and how we plan to achieve them. And go ahead.
Mr. Pelletier, I agree with you totally on this. For example, that Google Calendar.
Yep.
I use it myself now. I think what you have to do is just go in there and kind of play with what's in there for now and open up what's in there and find out what you can access and what you can't. But I think, and Dave's not here tonight, but he would be the one that would be able to put on all that other information for us, correct?
Anyone who has an account with the town can create a calendar and share it with anyone else. But so my theory would be that someone like the clerk's office could have a master calendar that included every meeting that she currently writes in the paper calendar, and Leona handwrites in the paper calendar. And if you grow a network with other organizations like the school and the library, you can all see what meetings are going on in real time, so you don't have to. There's not as much work involved in scheduling a meeting. You know what's available. You know what's not available. You can people. More importantly, people in the public can be immediately on notice every time a meeting gets scheduled for whatever particular board or commission or. The Secretary of State's office site is very clunky. You have to actively seek out the board and then sign up, whereas this could be a fairly seamless integration where if you have Gmail, it'll pop up in your calendar and you can turn it off or you can turn it on. It's pretty simple.
I think that's something that can be instituted immediately, kind of, with that type of information.
Yeah, sure.
Thank you.
Sure. The other one is just kind of, it's a subject in the governance policy. It's section, I don't actually have the current edition of the policy, but there is a section that outlines the specific way in which we craft our agenda and present the backup and then disseminate that information both to the council and to the members of the public. And every meeting in the since January, we've passed that deadline, and I wanted to talk about ways we could, in the future, streamline that process and try to get people on more engaged, because one instance is pretty glaring. January 25th meeting, we received it on Friday, January 22nd at 4:07 p.m., which is after town hall closed. And so theoretically, the people have less access to the information we're going to be talking about on Monday. And I think it's just generally good practice to get everybody on notice and get them information as soon as possible. So,
again, Council Pelletier, I agree with you totally. But I think there is a process that's in place now. We just have to adhere to it.
Yes, I agree. So I'll move that we I move that we put these on a next meeting or the meeting after, whichever Nancy sees fit for a conversation.
Second.
Brett,
Yep.
you'll be back in town at the next meeting, right?
When is the next meeting?
It'll be 2 weeks from tonight,
Yes.
yes. Okay. Because I don't want to put it on a meeting that you're not there.
Yeah, I come back the 22nd.
Okay. Do I have a motion to approve?
Second.
Okay. Motion been made and second. All those in favor? Unanimous. Presentations. Emera Energy Solar Farm presentation. And I want to thank you for waiting so long throughout it.
Good evening.
Good evening.
Madam President and Town Council of Tiverton. My name is Tim O'Connor. I'm Director of Business Development with Emera Inc. With me tonight is Sandy Hennequin. She's Vice President of U.S. Public Affairs for Emera Energy. I'll try to keep my comments brief, given the time of night, but tonight and beyond tonight, we're always happy to talk about Tiverton Power and our business there, our interest there, both with our existing facility as well as the Tiverton Industrial Park. So I believe one of the main reasons I'm here tonight is the town is considering alternative proposals for the industrial park. Recently, having heard from some solar developers for potential proposals from them to site a solar facility. And I appreciate the opportunity to speak to the proposal we submitted to the town last June. Happy to speak to that, as the thinking behind that, and allow the council and the town the full opportunity for a public discussion of our proposal relative to the others you've received. Again, in the interest of time, I won't go through all of the materials. You have them. Please ask any questions. But Emera purchased Tiverton Power in 2013, so roughly 3 years ago. We're an extremely proud owner of the facility. The employees there, all 20 of them, we are extremely proud members of the town of Tiverton, and we look forward to the ongoing business there. We continue to look for opportunities to grow our business as any business owner would. We've recently had an announcement of a long-term services agreement with GE, which I've referenced in the materials. We are also in the middle of a process to install some solar arrays on the rooftop of the plant, really just maximizing our investment there, looking for opportunities to grow the business, as I've said. I'll refer to the slides starting on slide 6 around our interest in the industrial park. Emera overall, Emera Energy specifically, we are continuously looking for renewable investment opportunities. We are always looking for gas opportunities, natural gas opportunities, to grow the business. Our existing site is 57 acres, which part of the consideration when the initial developer, EMI, purchased that was to allow for expansion over time. So there is some land currently unused within our footprint that we could utilize to invest in various energy projects. As the town has considered the industrial park, we felt there was some natural alignment between the town and Emera to work together on the development of the park. The addition of the park with our 57 acres would allow us some additional optionality to site different energy projects within that expanded footprint relative to the existing transmission infrastructure, relative to the natural gas pipeline, and just optimize the overall footprint. We've talked to you last year in executive session around some of the projects that we are evaluating on an ongoing basis. Last year, we were in the middle of the evaluation of a 100 megawatt natural gas-fired peaking facility. Market conditions proved not supportive of that investment at that time. It's not dead. It's basically sitting on a shelf waiting for the market to improve to a point where we're ready to try to advance that project. As I mentioned, we're already advancing the smaller solar opportunity, and that will be operational next year. We are currently looking at solar opportunities within the state. National Grid's regrowth program is about to kick off an RFP process for up to a 5 megawatt solar facility, which I believe is at least generating some of the additional interest you're getting from other solar developers, as it should. Longer term, as I said, the 57 acres allowed for expansion, and within the developer's initial planning, an additional 265 megawatt nameplate capacity gas-fired unit or facility was contemplated. I'd say right now the market would not support that new build from our perspective, but it is something that we look at over time and would be ready to engage going forward should the market materialize. LNG storage would be another option. I'm sure you hear enough, you read about the volatility in the New England power market. Having some on-site storage could be very good to have in terms of very cold winters, very hot summers, and being able to optimize the availability of natural gas for when the power market most needs it. The other piece, and I want to make sure this is clear, is that regardless of what eventually gets sited within the park, this is an opportunity from our perspective to further partner with the town. Over the past year, we've had extensive conversations. I've spent a lot of time talking with Mark, as well as some others, around what you guys are looking for. It's been clear that wind is you're not a big fan of wind. Anything maybe oil-based probably is not going to be very receptive either. Gas plants, solar, obviously right in our wheelhouse, and I believe is in direct alignment with what you would like to see out there as you guys consider the industrial park for an energy park. I feel, this is more my personal opinion, but it's strongly supported by the facts. We are a very strong partner candidate for this town. We are already there. We have an exemplary, we have a very exemplary record on safety, on the environment, on reliability, and we are very proud members of the community. We're there, we're willing to talk, we're willing to evaluate anything with you. And when I say that, that's not to the exclusion of other developers. When we first talked last June, we talked about purchasing the park. That didn't close the door necessarily on other developers still working in that park. It's not all Emera or nothing. It could be Emera and others along with the town, and I want to make that clear. Specifically, the proposal was to buy the full park at the time, and I believe you continue your discussions with Mr. Long around his facility. 158 total acres. There's somewhere in the neighborhood of 80 to 90 by our estimates of kind of usable acreage, developable acreage. And along with the upfront purchase price was the consideration around a tax agreement. We currently have a 20-year tax agreement. It began in 2000. It's set to end in 2020. For the upcoming budget year, we're slated to contribute $766,000 in tax revenues to the town. By the end of it, it'll be closer to $850,000. And so we offered to lock in a 20-year extension for the existing facility. And as I've noted there, that's roughly $850,000 in year one of the 20-year extension, growing to over $1.3 million, and that's roughly a 2.5% annual increase. The other component was modeled directly off the existing tax agreement in terms of new developments. One of the hardest things that we've faced here, or the challenge, and Mark can attest to this, is trying to say today what gets developed tomorrow. Okay? It's almost impossible. What we came up with was, if we purchased the land, there would be an upfront payment, a nominal payment of incremental tax revenues for that land until such time that an actual project was developed. We've talked about potentially having some sort of trigger mechanism in place to make sure that we weren't just sitting on the land. The $1.5 million up front was also a very significant incentive from our perspective to do something. We're not in the real estate business just to sit on some land. We offered at the time, and certainly open to further consideration, some sort of calculation based on output for the incremental revenues. That was the $2,000 per megawatt. There's also a current cap of 300 megawatts on the existing footprint, and so we would like to see that removed because we continue to look for opportunities. And the last piece, the infrastructure requirements cost of Tiverton, and this is after listening to what was important to Tiverton. We heard you weren't necessarily ready to invest more and more money into the park. You weren't ready to put more money into infrastructure. You weren't really looking for us to, put a proposal and then have, some other sort of tax agreement or financing agreement in place. There was no contingency in our proposal. It wasn't subject to a PPA, a purchase power agreement, getting secured down the road. It wasn't subject to any infrastructure improvements over time. It was $1.5 million up front, and we're going to develop this land because that's what we are. We're an energy developer. That was a non-binding letter of intent a year ago. What have we been doing since? The town has continued to evaluate its options, which were very supportive. We've met with Mr. Long to hear what he's doing, and and we'll consider working with him in whichever way makes sense, and we will continue that conversation with him. We continue to look at these projects. We are currently engaged with a third-party engineering consultant to look at the park. You've allowed us to enter the park with this third party to figure out what could be sited from a solar perspective, okay? Just because there's land doesn't mean you can put a solar farm there, and more importantly, even if you could, it may not be competitive in today's market. I don't need to tell you, you just need to drive down that street, Progress Way. That's very rocky land. It's sloped. It's not necessarily conducive to solar. Solar, you want nice, even land, no trees preferably, where you can catch the sun, okay? Now that said, some of our preliminary information, and I'd be happy to talk to you in executive session tonight or later around our findings with this consultant, but generally speaking, there is some siteability within the park. In other words, you could probably find a subset of the park to physically locate solar. The open question, and one that we do not have an answer yet, is at what cost? If it's going to be costly to bulldoze these rocks or to drill through them or whatever, all of a sudden you got a solar park that can't compete in today's market. We're doing that on our own dime, and we'll continue to look at that. That'll also pay off in other further considerations, whether it's a solar park, a gas plant, whatever it may be. We continue to monitor the market, whether it's Rhode Island, National Grid's regrowth program, whether it's New England from a larger sense. So let me just wrap up there. Again, I just want to reiterate, we are happy to talk with whomever, whenever. We value the relationship with the town. We look forward to growing our business, both what is there currently as well as what potentially could be there. With that, I'll take any questions.
Anyone have questions?
I just have a couple of very general questions. I assume you're continuing your conversations with Mark Russo at this point.
We are.
Okay. Here's the two concerns I have with the two issues. First, based on the preliminary work that you've done, is it your understanding that you'd be able to work with Jim Long, with Blue Sphere, with the other two solar companies? I mean, is that still in the cards at this point?
It is still in the cards. We would not.
You don't have to make a commitment, but I'd just like to get rough ideas.
And I won't make the commitment, but it is in the cards. I won't close the doors to considering those. As it relates those specifically to solar, and I saw one of the proposals recently made, I can say with a good degree of certainty, there is not 90 acres of solar availability in the park. There just
and I'm assuming you're still working with Mark in terms of the specifics.
Yes.
The other problem I had as I'm listening to this, at least with the solar proposals and the Blue Sphere proposal, and now yours, it seems awfully iffy. If somebody were to ask me, gee, when will that be up and running? I have absolutely no idea. Will it be up and running? I have no idea. In 10 years, in 5 years, I get that impression from talking to the Blue Sphere people, well, not talking to them, but listening to them, and the other solar groups. Would you be in a position at some point to really tell us, one, and this is what I'd like to know as a member of the town council, one, when can we look for something real there on the property in the industrial park? And two, what, within some rough number as to what the benefit to the town would be. That's what I'm interested in. I'd like to see more revenue coming into the town of Tiverton. I'm not interested in a proposal, like you say, well, at 1.5 million. And then you bank it for 10 or 20 years. Well, what has that done for the town? Nothing, at least in my impression. So that's why I'm also looking for some rough ideas that you might be working with Mark Russo on to give us something more concrete that we can vote on and assess as a member of the town council?
Welcome to my world as a business developer. It's not always.
I don't know if there is an answer.
I don't always have those answers, but let me give you a maybe a two-part answer here. One, I totally understand the question in terms of kind of a firm offer. You know, what are we talking about from a tax revenue perspective? I get that, and so just to go back to the original proposal and provide some of the thinking there. We thought it important, obviously, to put a meaningful number up front, and that was the $1.5 million, for precisely that reason. You know, without knowing specifically whether it's a solar facility, a gas facility, and the corresponding tax stream that would come from that, we assumed you guys would have a hard time signing up for that. And so an upfront cash payment of some, you know, with something behind it, felt like the right thing to do. The other mechanism in there, in terms of a dollar per megawatt, dollar per output, really, was to show that here is a revenue stream, and it needs to be revisited, frankly, in terms of the different technologies that could be cited there. But the thinking was, if we could partner with the town in terms of what could work for the town that is meaningful enough from an incremental revenue stream without knowing the specific project up front, that would give you at least a level of certainty that you don't have today. And or what you're seeing today, right now, from, let's say, a lease proposal, is you're seeing some concrete numbers that are heavily contingent on a whole host of things happening that may never happen. And our approach is, we're not going to just give you a conceptual agreement. That's why we're doing the work at the site now to figure out what is doable. We're not going to give you a concept idea, but we will give you what we can in terms of an upfront payment with a level of certainty going forward. What I can do with Mark, and what we've been trying to do, is what can the council get comfortable with in terms of that level of certainty on ongoing revenue stream, and how do we structure that in the agreement going forward. I view this very much as not an acquisition, but it would have been a partnership where we are the tenant there. We're the only tenant there, at least for the next little while. And we feel completely able to be able to deliver on energy parks once that market's there. But I do understand where you're coming from.
Well, in terms of the specifics, and I'll let it go at this point, but I assume that at some point Mark Russo will be able to report to the town council on exactly where all of these proposals stand and what the town gets out of it.
Absolutely. Yeah. But the other piece that is missing here is, you know, we proposed the 2,000 megawatt concept. What do you think of that? Where does it need to be? What's the magic number? We don't have that information yet. So without that, it's hard to come up with another.
Well, the magic number so far for 3 decades has been 0.
Exactly.
So if you promised me $1, I might take it. Okay.
Well, that's where the upfront payment comes.
That's an exaggeration. That's an. I know.
Madam President, please. If I could.
Yep, go ahead, Jeff.
Well, I can remember when the original tax agreement was reached, and basically what was told to the council was it was going to help with the financing of the plant, and basically the plant couldn't be built without a tax stabilization agreement. But we were never told that we were going to be asked to extend it. I was assuming that once this 20-year agreement was up, that they were going to come on and stop paying taxes like Tom's Market and everybody else is paying, full boat. So right there, I think there's a turnoff that we would extend. I mean, we haven't even reached the end. It doesn't reach until 2020, the end of extension, and we're talking about extending it to 2040 with the same type of a small increase where every other business in this town is paying the full boat. So I'm not happy with another tax agreement, at least not unless we see some larger numbers there. I mean, I'm assuming that they're not even paying close to 50% the assessed value. Second thing would be the land itself. I mean, I think what we've tried to do with that industrial park, and we just finally saw with the lawn complexes, it's not only just going to be a facility, but there's going to be jobs there for local people. And I don't see a lot of jobs, you know, with solar panels other than any installation. So I won't even be ready to agree to anything as far as solar panels up there. I really think that now that Long is up there, that this property is going to heat up and we're going to see a lot more offers. So, I mean, I don't want to waste Mayor's time as far as I'm concerned. I don't think I could even be in favor of any of this proposal.
Couple of questions. Could you answer Mr. Souza's stream, his comments about 50 cents to the dollar? His income stream, do you agree with anything that he had to say, or?
I really can't comment. I don't know. I don't know what full boat is in terms of Tiverton taxpayers. So.
I'm talking about what, for instance, Tom's Market has an assessed value on their property, and they pay 100% of. They don't have a tax agreement. Humphreys doesn't have a tax agreement. Sun, you know, the Sun gas station there doesn't have a tax agreement where they only have to pay, you know, half of their taxes on half of their assessment. The part of this agreement was to help that plant get built. You know, it helped pay the bonds. We worked with the business so that we could have a business in the industrial park. But it was a lot of people's understanding that once that tax agreement was over, similar to the enterprise zone, where people come in and they're on a 5-year plan, and at the end of the 5 years, they're paying the full amount of taxes. So I just think it's fair for all the businesses in town that if they have to pay the full boat, then the power plant should have to pay the full boat, or close to it.
Matt, could you comment on that, please?
Yeah, I don't want to get long-winded, but there is a time and a place and a set of circumstances that militate for a payment in lieu of taxes agreement. And early on, when this was, whatever it was at the time, Tiverton Power, or what it was called before Tiverton Power, this was a peaking plant, and it wasn't fully understood how often the plant would run and how much energy it would generate. It was there to supplement the grid when the grid required it. Am I correct? That's my understanding of a peaking plant. And so your revenue stream wasn't going to be, you couldn't chart it out with certainty going forward the way you would a plant that was going to run 24/7, 365. You just didn't have the same level of certainty. And so a pilot agreement is an appropriate economic development device in those circumstances to lock in revenue to the town that the town can rely upon at a level that wouldn't undermine the economics of a peaking facility. Typically, when you look at project finance, and that's what you're really talking about, almost all energy plants are project finance. You have a long-term revenue stream. You're managing one or two major sources of volatility. In your case, the cost of the raw resource that you convert into power and the final price of the power that you generate. The rest of it, it's fixed assets that with a long useful life that you might only improve once or twice. So once your fundamental model is in place, one of the major moving parts will then be local property taxes. If you were assessed the full boat, if you will, which would be the tangible tax rate on a per thousands of value, you would have a very large bill. It would probably undermine the project finance of your plants. There are experts out there, not a lot of them, but a few of them, that consult on most of these major deals in New England. They're involved in the Boroughville consideration right now. I would have to say, Tim, my recommendation to the council would be to retain the services of that type of consultant and work with Emera, frankly, to pay for those services. Because what you'll find is, in my personal opinion, 2,000 a megawatt is low. That's not what you're paying right now. You're paying closer to 3,000, or a little bit over 3,000 per megawatt. Probably closer to 3. And even relatively modest deals that are done other places in Rhode Island are more like 2,500. So we would be, but this is a negotiation, and this open session is the type of forum where we would conduct this back and forth negotiation. That consultant would take the hard, fast facts of your industry and your business and make a recommendation to all involved what would be an appropriate price that would allow your project to go forward and still allow the town to rely upon the revenue. Going forward, it's this, and Tim, you and I have spoken on the phone. I may have expressed myself differently, but I want to get to the same core point, which is help us all understand your job, because you're building facilities with a long, useful life that are a significant upfront fixed cost. You have very little labor, so you have very little variable costs are going to go into these plants. And yet, from time to time, when those of us who are not in your industry talk to you, it seems like you're watching the energy future prices for the next couple of years to make that decision. And I guess I have a hard time understanding that. I need to understand how you make investment decisions at Emera and in the industry in general.
Okay, I'll try to be brief on that as well. You're right. We invest over the longer term. We don't make investments, in a short time frame, a 1 to 5, even a 10-year time frame necessarily. My job is to find energy projects where we can invest our money to get a suitable return on our capital. I guess that's really simple, maybe overly simplified. That's my job. As it relates to the energy markets, when you're making an investment of the sizes that we make investments in assets that can be 25-year assets, 40-year assets, you have to have a view of the future. Anything beyond 10 years is an educated guess, right? You have to watch the markets from a natural gas generation perspective, both from the price of gas and the price of energy, as well as the capacity market, which supports new build economics in New England. That is the view. When I talk about the future, all three of those components have to come together when you build a plant or even buy one, in terms of the ongoing variable and fixed costs of the plant and the upfront investment. When you put all that together, does that return meet the thresholds we require from Emera to invest our capital? Somewhat simple explanation there, but that's effectively what we're doing.
So, just to play a quick game of Goldilocks, are we even close to being warm enough, or is this? Do you really see this as a long-term?
No, we're always warm. I think we're constantly evaluating. September of this year, we were working full tilt on advancing a 100-megawatt gas plant, and we were ready to bid it into the February 2016 capacity auction. A number of developments occurred, and the market wasn't there, and it was proved out with the auction results. The prices that new build cleared in the most recent auction would not have supported our investment. And so we made the right call. That project is ready to go should the market return to a level that's suitable, and we'll advance it then. Right now, solar is a bit hotter because, as I mentioned, the National Grid program in Rhode Island is actively seeking solar energy. And so they're offering some long-term contracts in support of that. New England, and I'm sure you guys have heard about this, New England is actively looking to they need to meet their RPS standards. And so solar development in New England, wind in New England, can be supported probably in the near term. But my job is to find those projects where the market conditions and the project attributes come together to provide a suitable return. Is that helpful?
So I have one more question then. The solar power, not for you, Tim. You can only have one on that, so only one, Jay. But if we do pick a solar energy, only one, 35,000 megawatt thing can be put in there.
It's roughly, rule of thumb, 4 to 5 acres per megawatt. So assuming, let's say this RFP through National Grid, they're seeking up to 5, so that's 25-ish acres. You're not going to put many more megawatts than 5, most likely in that park. And so any solar developer would obviously be looking for what portions of that park make the most sense. The northern portion of the land north of Just Progress Way, just to the west of our facility, where Mr. Long is looking. That roadway area might be pretty good because it's already cleared. It's a little bit more elevated as well, but that may be taken out with Mr. Long. So that consideration is ongoing, and we're doing a lot of the geotechnical analysis to figure out what has to be done with the land itself. Everyone knows it's rocky, but can you still maybe site some solar panels there regardless?
Anyone else?
One other thing, that's that you talked about the topography. I've actually walked an entire park, used to hunt in there, and there are a lot of areas that, well, if you look where solar usually is, you look at other sites, they tend to want the tops and the southern exposures, but it'd be the parts of land that are the most valuable because they're the easiest to develop, which would leave us with the gullies and areas that border wetlands and things like that. So it's, you know, it's the best part of the land. It just doesn't seem like a good use of the land if we're actually trying to grow jobs in town.
I think it would be a good, my personal opinion is to continue a relationship with the mayor. So your offer, is that still on the table? Are we still discussing everything, Tim?
We're looking at this site assessment once this is completed, which should be approximately the end of the month.
And you'll have a better idea?
We'll have a better idea of what can and can't be cited there. But I echo your comments in terms of continuing the conversation. Whether we do anything in the park or not, we see an integral role in staying involved with this town council. We have 57 acres there that even if we don't do anything in the park, we will actively be looking to do something there. And so the doors are open, the phone's always available.
2 weeks or so you can come back to us, or 30 days?
When you get what you need, contact Mark and the town administrator, and then we'll put you right on the agenda. Okay, but I'll wait until you are prepared to come back. Is that okay, Peter?
Yes.
Yeah, okay. Anyone else?
I just have a couple of comments.
Sure.
Thank you very much for coming out here. I guess what I wanted to just sort of talk about back and forth is, and we constantly talk about trying to fit everyone in the industrial park, Blue Sphere, solar guys, everybody that wants a piece of land, we're going to accommodate them. And we've been doing that for quite a long time. And I think we do that at the risk of not doing anything. And Jay mentioned what we talk about all the time is what we get and when and how soon we can get it. Well, we've been having that conversation for so long. If you look back in time, we haven't gotten anything, and we're no closer than we are today. We have owned this industrial park longer than, dare I say, I've been alive. And it's pretty much looked the way it looks now for most of that time. I know part of my job is to make you guys feel older than you probably already do, and make myself feel younger than I look. But I think a point to Amera, and I actually don't remember what the plant was called when it was built, but every iteration of this facility has been a good neighbor, been a good steward of the property, so much so that when we talk about the end users of the industrial park, we sort of swing way back and forth. We want jobs and we want an asset to the community that pays taxes, but we also don't want the traffic that a retail facility would draw. We don't want the traffic that maybe a warehousing facility with trucks in and out would cost. And my mother's not going to like this if she sees it on television, but my mother's lived in Tiverton since 1976, and only last year did she find out that there was a power plant in Tiverton. And that is not uncommon. There are lots of people that go, power plant, where? And I say, go to Portsmouth and look over, and you'll see it. So, we have to balance those things. I think, to Joe's point about wanting jobs, we've wanted tenants to bring jobs into this community, into the industrial park, for 30-plus years. I don't know at what point you stop saying, all right, we're willing to make a deal with a user that maybe won't employ the entire town, but also is a good neighbor and a good user of the land. Because if you think about it, we're not doing anybody any favors holding out for that one manufacturer, that one facility, that one user that's going to employ 500 or 1,000 people. Because in doing that for decades, what we have done is not created any jobs whatsoever. And if that's the function going forward, it's really, you got to make a decision and say, all right, well, we're either going to continue to hold out for hope that somehow some facility like, I don't even know what, is going to come in and going to employ a lot of people, or we're going to try to cobble together 6 or 7 different tenants, and we're going to be in the real estate business, and we're going to make deals. Or we look harder at a deal like this, which doesn't necessarily have immediate substantial payoffs. We're not going to be cashing checks of millions of dollars a year and employing everybody that wants to, and also at the same time not having any additional traffic or excess pollution or any of those other things that come with high traffic and high utility areas. I think this is a good deal. I think you've been good tenants. You've been very good community stewards. And I hope we can continue a serious conversation about your role going forward and our role going forward. Maybe I've been not straightforward with this, but in the past. But I genuinely don't think, this is my personal opinion as a town council member and my professional opinion as a real estate consultant for the last 11 or 12 years. I don't think we can effectively and successfully accommodate everyone on that site. I don't think we get Amera. I don't think we get Blue Sphere. I don't think we get whatever the other 2 solar guys are, and I don't think we get any other who knows what, and still have something we can efficiently use. There's going to be something that falls apart in a deal like that, and you're going to end up with a chunk of land that nobody wants, and maybe some less than stellar efficiencies in the market. And I think to avoid that, I think it's worth serious consideration to get back to the numbers and see what Amera has to offer. And frankly, everybody knows that site is all over the place. I mean, we're not engineers or land surveyors or solar developers, but I think everybody intuitively knew that 100 acres of solar panels in the industrial park didn't make any sense, and doesn't make any sense unless you cut every single tree down and put them on stilts, which is not going to happen. So anyway, that's long story short, or short story long. I think we ought to do exactly what Peter and Denise just said. When you're done your diligence on the capacities of the site, come back to us and we'll start talking in earnest. And we can I would hope we would evaluate that as a comprehensive conversation, because I don't think we're ever going to get 100% apples to apples, because I think when we talk to developers that are even more speculative than Amera is, I don't remember their names, but some of the solar people that not only had they not ever been on the site, they had never seen the site, even from afar. So, we're even further behind the deal on that one, because they've got site diligence to do. They probably should walk the site and get some measurements and stuff. So, anyway, that's my thought.
Anyone else? Thank you very much.
Thank you.
Mrs. Blackhat, do you have something to say?
Yes, please. Sally Black, liaison to the town council from the school committee.
Mr. Pelletier said a few times about them being a good neighbor, and I'd just like all of you to know what an amazing neighbor they've been to the schools. I've been over there a few times to collect checks that they've donated to the schools. They've also donated computers for us to use for our Cyber Patriot team, because our computers couldn't bear what those things had to do. And we recently had 5 teams from the middle school go up and get awards, and 3 of them were girls. And as you saw what's happening lately, that's what's going to be fighting the latest wars. It's going to be our kids competing against them to find out what's going on. And so I just wanted to say that they also work with us with our STEM and STEAM, and they've been amazing. Thank you very much.
Thank you, Sally. Okay, I guess we'll move on.
Oh, one other thing. You guys promised a tour, and I'm still waiting for that.
Oh, and she's going to give it to you.
All right, thank you.
I'll be around after, so I can give you my contact information. We can set that up.
Okay, thank you.
If it's okay with the council, I'd like to entertain a motion to maybe bring up the appointments, because I know there's at least 1 or 2 people in the audience that's waiting to be appointed, and then we can go back to the public presentation. So it's
Actually, Madam President, I was going to move that we move up D 1, 2, 3, 4, and F. Those are just transfers. Those will be very quick. F 1, 2, and 3.
Second.
F1 and 2. Okay, motion's been made and second. All those in favor? Okay, unanimous. Resignation, Scott Humphrey, Economic Development Commission. I'd like to entertain a motion to accept his resignation with regret and thank him for his many years of service.
So moved.
Second.
Motion's been made and second. All those in favor? Appointments, Conservation Commission, 1 vacancy, a 3-year term, up to 4/15/2019. Patricia Hilton, 99 Peaceful Way. We all know this is a reappointment. Trish, is there anything you'd like to say? You want to tell us why you want to be reappointed? If you feel like it.
I'm not sure if I really thought about the answer to that question, whether
That's
or
what
not I
I
actually want to be reappointed. But I think if anything, we have a great conservation commission. I work with wonderful people. I think we do a little bit of good here and there, but I really do enjoy working with my fellow conservation commissioners and would like to continue to do so.
Thank you. I'll make a motion to reappoint Tricia Hilton, 99 Peaceful Way, to a 3-year term expiring 4/15/2019 to the Conservation Commission.
Second.
Motion's been made in second. All those in favor? Welcome. Thank you, Trish. Housing Authority, 2 vacancies, 5-year term, 10/15/2020, 4-year term. Jeannie Mae Durfee, 2411 Main Road, request reappointment.
Madam President, I'll make a motion.
Well, Jeannie's here, so Jeannie
she's
has
coming up
been
to speak.
waiting.
Come on up.
If you'd like. Hi, Jean.
Hi.
Would like to give us a brief reason why you want to be reappointed, or?
Well, I've been on the Housing Commission for 5 years now. It's been very enjoyable. My mother was the director, and I was very involved all the time that she was the director, as far as seeing the residents and helping out and, just going up there when my mother was there. Prior to when she passed, I told her that something I would like to do would be to help out the Tiverton community, be on the board, because it was something I was familiar with from growing up. I also have a healthcare background, 30 plus years as a nurse, new nurse practitioner this year, and I just feel as though those are some of my people. So I'd like to continue my good work there. I enjoy working with the other board members, and Nancy is fantastic to work with as a director.
Any questions? Like to entertain a motion?
Now I'll make that motion?
Yeah, not I just figured she waited, she should say something.
To reappoint Jeannie Mae Durfee, 2411 Main Road, to a 5-year term, expire 10/15/2020.
Second.
The Housing Authority.
Motion's been made in second. All those in favor? Thank you. Zoning Board of Review, 1 vacancy, a 5-year term, 7/15/2021, David B. Collins, 4001 Main Road, request reappointment. Is Mr. Collins here? Come on up. Would you like to tell us why you want to be reappointed, please?
As you're probably aware, I've been a member for quite a while, and at this point, the board is in a bit of a crisis in that we are short 2 members. We have 2 vacancies, and if I don't continue, then the board can't continue because we won't have a quorum, and if a new member is brought in, at that point, they would not be able to go through the normal training period. So I feel that in order to keep continuity with the zoning board and to take advantage of or to enhance everything I've done over the last 39 years as a member of the board, that it would be the right thing to do to continue. So I am asking you to reappoint me.
Whatever it takes to keep you, Dave.
Any questions?
First of all, I'd like to thank you for your 39 years of service. I've been to the zoning board meetings, and I want to thank you for your efforts on what you do. Now I'll make the motion to reappoint David B. Collins, 4001 Main Road, for a 5-year term expiring 7/15/2021 to the Zoning Board of Review.
Second.
Motion been made in second. All those in favor? Unanimous. Thank you very much. Financial business. Chief Lloyd is not here right now, but I imagine, Matt, you could handle this? Okay. Request transfer of $5,000 from account 3310-7611 fuel, oil, and tires to account 3310-7640 apparatus maintenance.
Madam President, by and large, there are no single one reason why these transfers are occurring. They're end of the year cleanups to make sure we don't run deficits in some accounts when we're running surpluses in others. So I can brief you quickly. As a general matter, the 2 public safety departments are running small surpluses in their fuel accounts because the price of gasoline and diesel has been below what was projected when the budget was passed last year. So to the extent that they're running short in other accounts, that's where they're going to be drawing funds from, their fuel accounts.
Okay. I'd like to entertain a motion to request for the first transfer of $5,000 fuel, oil, and tires to apparatus maintenance.
Madam President, I'll make the motion for the transfer, but first I'd like to, I'm looking at 7640, the account that's being transferred into the apparatus account. We already have looks like we had a budget transfer of $10,000 into there a while back. So I hope that this year's budget is more accurate than the one we have now.
Madam President, I just would like to remind members of the council that we have probably at this point spent almost $17,000 just fixing one rescue.
One rescue?
Yeah.
Okay. I know the 2 of them were both out at the same time.
At one point, all 3 of them were out.
All 3 of them, okay.
And engine 5.
Okay. So I'll make that motion to transfer $5,000 from account 3310-7611, fuel, oil, and tires to account 33107640, apparatus maintenance.
Do I have a second? Motion's been made and second. All those in favor? Request transfer of $3,500 from account 3310-6968 medical physicals to account 3310-6969 medical supplies. I'd like to entertain a motion.
I'll make that in form of a motion, Madam President, to transfer $3,500 from account 3310-6968 medical physicals to account 3310-6969 medical supplies.
Second.
Motion been made and second. All those in favor? Unanimous. Request transfer $3,400 from account 3310-5108 longevity to account 3310-7530 software maintenance. I didn't say
Madam
it.
President, I'll make the motion to transfer $3,400 from account 3310-5108 longevity to account 3310-7530 software maintenance.
Second.
Motion's been made and second. All those in favor? The Police Department request transfer of $10,740 from account 3330-5107 holiday to account 3330-6928 education.
Madam President, I'll make a motion to transfer $10,740 from account 3330-5107 holiday to account 3330-6928 education.
Second.
Motion's been made and second. All those in favor? Unanimous.
That was for 3 officers, I believe, that attended Boston College. So it's in the backup.
Yeah, I believe you're right. Request transfer of $6,600 from account 3330-7611 gas account to account 3330-6648 auto parts.
Madam President, I'll make a motion to transfer $6,600 from account 3330-7611 fuel, oil, and gas to account 3330-6648 auto parts.
Second.
Motion's been made in second. All those in favor? Unanimous. Request transfer of $9,600 from account 3330-5102 ASME salaries to account 3330-5168 clothing allowance.
Madam President, I'll make a motion to transfer $9,600 from account 3330-5102 AFSCME salaries to account 3330-5168 clothing allowance.
Second.
Motion's been made in second. All those in favor? Unanimous. And Town Administrator, approval of $122,170.35 transfer from account 3310-5101 fire personnel services to account 2352.95 unfunded library. What? Unfunded, it says library though. Okay.
The Freudian slip.
Because I was gonna actually ask what an unfunded library was, because of our earlier discussions. So liability.
Yeah, unfunded liability.
I know, I was wondering. To cover
We just unfunded the
town's
library.
expenses related to FLSA attached listing.
I'll make a motion, Madam President, to approve $122,170.35 from account 3310-5101 fire personnel services to account 2300-5295 unfunded liability to cover the town expense related to FLSA attached listings. And I want to thank Matt for doing this.
Second, I would appreciate if Matt would explain to the public exactly what this transfer was for, because it's kind of large.
Yeah.
Madam President, I'll answer Councilman Souza's question. I believe when we came out of executive session at one point, I don't think there were very many members of the public still in the room, but an explanation was given that the town of Tiverton, with 3 of its 4 labor unions, engaged in a dispute over the calculation of overtime payments over the course of several years looking back. Upon advice of legal counsel, all parties involved agreed not to pursue that dispute to legal resolution, but to arrive at a monetary amount that would satisfy both sides and the needs of both sides. It's important to note that the fire contract, with significant changes to the base salary line, allowed for the settlement of this dispute within the budget that existed for the town of Tiverton for this year. And at this point, all members have signed their waivers, including all retired or otherwise departed members, and therefore we believe this matter has been resolved. I thank the council for its support through what was a tedious process.
I have a motion on the floor in a second. All those in favor? Unanimous. Thank you. Public hearing to amend ordinance Chapter 5436, Article 2, Recreation Areas regarding recreation equipment, rental businesses.
Madam President?
Yes.
This ordinance is designed to address the issue of vendors which would like to use town property to lease recreational equipment such as kayaks. I understand there is a particular vendor that has expressed an interest in doing this. We were asked to draft an ordinance to allow for this, but also to protect the town for this type of activity if it is in fact approved by the town council. And as you can see from the ordinance, there is language in there for an indemnification agreement and also for a requirement for liability insurance with a minimum amount of $1 million in coverage, and the pay a fee that's set by the council through resolution. The council would have absolute discretion to grant with conditions or deny any request to use town recreation area land for an operation of this nature for the rental of recreation equipment. If you have any questions, be happy to answer them.
Any questions from the council?
Just, it says town recreation land. Do we define what that is in our ordinances, or is that just something we can modify as we go?
Nancy advises me that there is a definition for recreation lands, beaches, and things of that nature.
Okay.
Any other discussion from the council? At this time, I'd like to open it up to the public for any comment or questions.
I'm here specifically to go in front of the council for approval of my signs for my registration organization.
Right. That is later on. Yeah. All right. Any other questions and comments? John?
That's up to the council. This is specifically for the rental of recreational equipment. So whatever you think is appropriate, you can include in the proposed ordinance, and it would be an easy amendment. recreation land, as you see in the first paragraph, would just be changed to town-owned beaches.
I mean, this doesn't include food, which you've already prohibited at certain areas. I think it's something like 500 feet or 200 feet within a recreation area. The one thing I'm thinking of is we have other areas such as Boogamarsh that might be appropriate. I'm having a hard time foreseeing an instance where you would have a vendor wanting to rent recreational equipment at, say, Town Farm. I mean, what, bikes? Or I mean, and that would go in front of the council on a as-is basis, right? We would be permitting this, so it's.
That's correct.
You know, I can't imagine there's a heck of a lot of money to be made renting equipment, sporting equipment to people at Town Farm. That's just my own.
And each and every one of these would come to us, so we could stop it at that point.
Well, it also says that it needs a positive recommendation from the responsible commission. So they would have to come to the Recreation Commission to get your positive recommendation before it would come to us to license them. So you would have a say in whether they could, you could have at Town Farm, maybe during the winter time, they could rent cross-country skis. You know, there are potential possibilities. So I'd rather leave it open, and then at least they come before your commission to get approval to move forward with the process.
Just come on up. You don't need to raise your hand.
I have a question on as far as vendors. If I have a tournament and I use the facilities, and you guys just went over the food thing, if I have a food truck with its own food licenses within the state of Rhode Island, could they come to my tournament, my softball tournament, and serve their food on rec property, knowing they have all their sufficient licenses? Obviously, they wouldn't have a food truck if they didn't.
No.
Go ahead, Tony.
That's a hawker peddler license. They need to be licensed for that.
But we have an ordinance that prohibits the sale of food and drinks within a certain radius of the ball fields. It used to include the beaches as well, and we removed the beaches out of the equation so we could have food trucks at Grinnell's and Fogland. But as it stands right now, I do not
Even for an event, I would look at the process of an event.
Tony can talk to any exemption that would be given, but I don't believe so. Unless Boogamarsh is carved out, I don't know the ordinance.
Because that puts me in a situation where I can't offer my families food because all the facilities are owned by the Little Leagues. So I would have to somehow provide food for hundreds of kids. And the only way for me to do that is either build a facility or bring a food truck with its own license to get safety behind it.
I think we could work around that with our special event ordinance.
Yeah.
Well, we have to work around the main ordinance, which says that's not allowed. Which I think we could draft some language that said, maybe a special exception or on certain event days or whatever it is. There's certainly a way around it.
Madam President, I have just one question. The two trucks that are authorized on the beaches, there are two, correct, that are authorized on the beaches?
On Fogland, yes.
On Fogland and Grinnell's?
Yeah, but there's one in particular that goes to Fogland every weekend, right, Matt? There's one in particular. And then the others kind of...
So they could apply if they have a special tournament coming? Could they also go to that special tournament?
Brett's saying technically no, because it's a sporting...
I'm not an attorney, but what the language as I remember it is you're not allowed to sell food within, it's either 200 feet or 500 feet of these designated recreation areas. And I think it's generally the Little League areas, so all the ball fields. It used to include the beaches as well, but we took the beaches out. I'm not like I said, I'm not an attorney, but technically I don't think if you wanted to serve food in a food truck, you would be allowed to do that.
So
like I said, John's point is good. I don't think the Little League would care if you showed up and there was a special exemption if they weren't using the field. They're not losing out on any revenue or anything like that. But
would that require a special use permit, though, to do something?
You need to make an amendment to the ordinance to
So
allow for that.
they could request a special use permit and be able to go down there and take care of the ball fields. Okay. Thank you.
I still have an open public forum. Anyone else from the audience like to comment or question? Anyone else? I'll close the public hearing and entertain a motion.
move that we approve the amendment to ordinance chapter 5436, Article 2, regarding recreation equipment rental businesses.
Second.
Motion's been made in second. All those in favor? Unanimous. Town Administrator, approval of proposed amendments to fees and fines.
The prolonged silence, Madam President, is me trying to figure out just what the council's appetite is at this hour for this document. I'm more than happy to go through it, or at least try to get part of the way through it. There are several items on my attached memo where I have made specific recommendations to the council, where we've done additional research since your initial public hearing. The first of these, and I think when our boards and commissions work very hard and come up with data-driven or data-supported recommendations, I hope that we would respect their efforts, as long as those efforts appear to be reasonable, calculated to achieve the revenue goals that we have for those activities. So the first of these is the mooring fees recommendation that came to the council at that meeting back in, I believe it was February. You'll remember Chairman Bruce Cox was testifying about changing the fee structure so that he could accommodate the differences in size between vessels should actually tie back to the fee that they pay. That the larger the vessel, the more of a accommodation it was to have it there, and they should pay a higher fee, as opposed to modest boaters mooring modest vessels. So those recommendations appear, and bear with me, on page 2 of this chart. But the page 2 of the chart refers you back to the handout that was provided, and I hope it's here, Nancy, by Chairman Cox back in February. And that's probably 1, 2, 3 pages deep. It's entitled Recommended 2017-2017 Mooring Fees. And it was handed out on the 29th of February. And so your principal change here is in the boat length being taken into consideration in the calculation of the fee. And you can see here that the commission estimates that this would be for all intents and purposes, a revenue neutral proposal, but would be more fair to those owners of small boats.
Any questions? On that particular page or the whole document, it's up to you.
Turn your mic on, Joe.
Page 5, just one that sticks out to me, and I talked about this already, the flea market, an increase of 350 to 500. Basically, they're open 2 days a week. They're paying $350 for the license and an additional $50 for the Sunday license. So they're already paying $400 a year to the town to be open 2 days a week. I don't know why we'd want to even touch this fee.
Matt?
So, Madam President, I would refer Councilor Souza to page 2 of my memo, item number 3, flea markets. So I summarize what the proposal is, but that's not the recommendation. If you read further into the text, 17 of 39 cities and towns issue flea market licenses with annual fees ranging from $0 to $750. Tiverton is currently the second highest in the state at $350 a year. The most common value is $100 a year charged by 5 of the 17 communities that issue the license. So that being the case, Councilor, I think the weight of the evidence supports your position that $350 is too high compared to other communities in Rhode Island. And the remaining question for the town council would be, since there is only one issued, and it is a pre-existing non-conforming use, as a matter of policy, how do you want to stand on this? And I would only reflect on the fact that we've spent the better part of the last couple of weeks discussing with the council, with the budget committee, very large numbers. So the difference to me between $350 and $100 is completely meaningless in terms of the grand scheme of the budget. It all has to do with the relationships with people, in this case, the same ownership, and they're engaging now in an improvement effort. So I guess I'm indifferent as to the money, and I'd be perfectly satisfied if you actually reduce this fee.
Reduce it back to $350?
The license will still trigger the inspection requirements. You won't lose your regulatory authority by reducing the fee in any way.
Well, we don't need a motion to just leave it the same. I think we should just pretty much just leave it the same. That's my opinion.
Anything else?
Actually, I think with the lateness of the hour, there are over like 20 items on this that require changes. Is there anything in here that's critical that we have to decide on this tonight? I would really prefer to continue this to the next meeting.
The only, and I do agree with you, it's just we keep continuing this, so at some point, we've got to put this in the front of the agenda, I think, and just go for it.
Madam President, it's already quarter past.
Oh, I agree. I agree with you.
Quarter past 10, and there's not very many people left in the audience.
John, I will open the public hearing if you want to speak, but could you come to the microphone?
Did the beach fee make it on there? For Grinnell's?
I think last time we published this, you didn't even have a commission yet.
Yeah.
But I actually, this is timely, and it is necessary. The recommendation, was it unanimous at your
Yes.
commission? Was to return the Grinnell's beach fee back to its prior level.
Of $5 during the week and $10 on the weekend.
Go ahead, explain it, John.
Grinnell's only. Grinnell's Beach, I believe it was in 2014-15, we increased the fees at Grinnell's to match Fogland. $10 during the week, $15 on the weekend and holidays. We basically lost money at Grinnell's Beach that year. People were turning around and leaving when they saw the increase in the fee for Grinnell's. Fogland carried us through, so we weren't at a complete deficit, but if we looked at Grinnell's Beach alone, we were losing money, especially during the week at Grinnell's Beach. had a few figures here. I do not have the revenue. It is almost impossible to break that out of information from the treasurer's office because it just goes in to the same account, both beaches. I did a little math earlier. I seem to have misplaced it, but it basically, oh, here it is. With lifeguard and gate attendant, 6 hours a day, each day is $132. It costs us to open the beach. That's $924 a week. There were some days during the week where we didn't even generate $50 at Grinnell's Beach. So our hope is to rejuvenate a little bit of revenue back to at Grinnell's until the beach is improved and that project is complete. Then we can come back to it again and try to get a little more revenue out of there. But it doesn't make sense to me. I mean, if it was me, if I was running the business of Tiverton and I was losing money at Grinnell's Beach, I would much rather close it than have the liability of employees at a beach that isn't making money.
Madam President, please. I'm assuming that the majority of the money raised for parking and fees is going to pay the lifeguards. Maybe it's just my opinion, but I'd like to see just have it be free to go to the beach and let parents just be responsible for their own children and not have a lifeguard. That's just my opinion.
Well, it is free to the citizens of Tiverton. Town residents go to the beach free. They get a free pass.
Still got to pay for a lifeguard.
But the liability
right.
there.
The fees are for non-residents.
Well,
fees are for non-residents.
I don't know. To me, you should be able to go to the beach for free. That's just me. I grew up in Island Park. You didn't pay for the beach over there, and I don't see where it's a big problem over there. So you don't have a lifeguard.
So what are you suggesting, John, that we go back to
$5 per vehicle for a car or truck on weekdays, $10 on weekends and holidays, and we'll leave the RV fee at $25, regardless of the day.
Sorry, this is just for Grinnell's?
Just for Grinnell's.
So we'll have to create
Grinnell's only.
And keep Fogland the way it is.
Yes, that worked fine.
Any discussion from the council? Any discussion from the audience regarding this?
Madam President, not to belabor the fact or this meeting's duration, but we certainly learned that we have two entirely different audiences with our two small beaches. Fogland is an active recreation site. Many of the people who frequent Fogland Beach, if they're non-residents, are there for hobbies that they really can't do in very many other places. So they're insensitive to the price. But Grinnell's is a working man's beach. It's where you go on a real hot day, and it's cheap and affordable, and there's limited parking, and $5 when people either park in the neighborhood or try to dodge this. And as soon as the gatekeeper leaves, a long line of traffic moves in. And they might have been willing to pay the $5. We would have gotten something for it.
We would have got something.
That's where the recommendation comes from.
Yep.
Okay,
I
so
think that's fine. I just wanted to say, I hope when we see some substantive progress at Grinnell's Beach, we will revisit this issue with consideration to the policies that we have down there, the parking enforcement in the neighborhood, et cetera. Because I do think once we have an asset that's worth preserving, we ought to do our very best to preserve it.
So, I'd like to entertain a motion to change the fees at Grinnell's Beach from $5 for cars and trucks during the week and $10 on weekends and holidays, and keep the RV at $25. And also, I guess, to entertain a motion to continue this discussion until the next meeting.
Can you just specify when you're talking about charging the fee, it is for in town or only out of town?
Non-residents.
Non-residents.
I didn't hear your question, but.
Well, I don't know, I mean, we want to bring people into the town that would actually go across the street and eat in the restaurant and stuff, so, I don't know. It seems like a beach is a
But
good
if you don't pay
attraction.
$5 to
Yeah.
get into Grinnell's, you're not
gonna
going to the
go
Red Dory.
No.
$10 beer.
Okay,
You never know.
We're
You
gonna
never know.
all right, to try to speed this along, do I have a motion? Would anyone like to offer a motion? I need a motion to change the Grinnell's Beach fees and then to continue fines and fees until the next meeting again.
I'll make that in form of a motion.
Second.
Motion's been made in second. All those in favor? Against? What did you vote?
2 opposed.
No. So Nancy, did you get it? It was 5-2? Yeah. Brett and Joe. Yeah. The bookend. All right, new business. Lou Farias, New England Softball Club President, request for signs on town fields.
Excuse it, Tara, I came from boxing class, so I'm sorry.
That's okay.
There's nothing I can do about that. My sign, I believe, you guys have a copy of it? Correct? Yes. That is the sign that's going to go up at 2 locations at Town Farm at Bogomash. It says Portsmouth High School because it's been such a struggle to get my fields here in town. I didn't have the time, or I didn't have the fields at the time to put Bogomash on there. I presently have Portsmouth High School with the administration and multiple fields across the state of Rhode Island and Massachusetts. This one seems to be the hardest to gain, and I live in this town. But my organizations, I would like it to be all Tiverton players, so it could be a C recreational travel program instead of a B recreational travel program, which it currently is because it has out-of-town kids. I live in town. I've been living in this town for over 7-8 years now. And I'd like to promote ASA softball here in this town to bring it up to the next level so they stop getting their butts kicked by Cranston and Warwick on a regular basis in the States.
Now, the reason why, Tony, the reason why he had to ask for our permission is because it is advertising an out-of-town field. Is that correct?
Under the zoning ordinance, town council gives permission for these types of signs at these types of fields. So town council permission is needed.
Madam President, question.
Sure.
What's the duration that these signs would be on the field?
Until the day, August 27th, which is the day of my tryout.
So it'd be, how long would they be up approximately?
If he puts them up tomorrow, a month and a half.
A month and a half? From present day to the day
I
of
mean,
my
are these
tryout.
permanent, or are these something that
No,
go up
it's
a
a
couple?
lawn flower that goes in with your foot and you take it out. With
All
your
right, so it goes up like a week before the event? Well, the only reason I bring it up is we have the Little League, they're allowed to put their banners up around, and they're required to maintain, and, if there's a heavy wind and things like that.
I live right around the corner, so I could
Yeah.
do the appropriate
I
maintenance
think that,
myself in the
well,
signs.
the thing was that the people that live in that area were afraid that they would fly off and come over into their yards or whatever, so that's what I'm talking about with the duration, the type of sign, with temporary signs, if they're up too long, they tend to degrade.
Right, of course.
And that was an issue out there, so to keep the neighbors happy and,
Well,
that's
being the
what-
president and the treasurer, I paid for those signs, so rest assured when it's windy, they're gonna come down.
The only question I had was you booked the fields for the time, so you're all set with going through the Recreation Commission to book the time slot for
that tryout?
Yeah.
At the Portsmouth High School.
Oh, it's still, okay.
Because I still don't have my fields, and I've submitted my request twice. I could not put Bogomash on my sign because I technically did not have permission yet.
I see what you mean.
So at the time when the flyers were made, I had to put down the field that
They were
I
gonna
had
do,
access to immediately.
Sure.
I
Sorry
can't,
about that,
I can't wait
misunderstood.
forever.
Any other questions from the council? I'd like to entertain a motion.
Yeah, I'll move that we approve 2 lawn signs for Town Farm Field and Booker Marsh Field. Actually, I'm not going to say 2. I'm going to say, you're just going to have 2, or?
Just 2 signs at 2 locations.
Oh, 2, okay, so
One sign.
2 signs, 1 and 1?
1 and 1.
All right, so 2 signs, 1 at Town Farm and 1 at Booker Marsh Field, to be up until August 27th.
So moved.
Anything else? Anything else? No?
I just have one question, Madam President.
Yes, sir.
Who authorizes the use of the fields?
Who authorizes the field use is the rec committee and the town administrator, and my requests have been submitted twice. And can I add, I had these fields last year. I have keys to the facilities. My organization information has been in there. Nothing has changed. So for this to have this delay, as a military veteran, I'm frankly insulted.
Thank you.
We are sorry about that.
We'll see if we can get it moved on.
But John's working on it. He's right
John's
back
working on
here.
it.
Motion's been made in second. All those in favor? Unanimous. Thank you.
Appreciate it.
Town Solicitor, appointment of special legal counsel for enforcement relating to Four Corners Property, LLC. Tony?
Due to litigation that does not involve the town, I will have to recuse myself on matters involving Four Corners Properties, LLC, and I'm going to turn it over to the administrator at this point because I think you need to appoint special legal counsel for those enforcement matters.
Town Administrator?
Madam President, as you may recall, members of the council may recall, we are engaged at any given time in a significant number of regulatory entanglements with different businesses operating at Four Corners and how they interact with one another and the infrastructure of the properties and whether or not that infrastructure supports the uses that are currently in place. Conversation, for the most part, is civil and civilized, but there are certainly moments when the interaction of state environmental regulation, the town's zoning code, the building code, and other relevant regulations that arise from time to time, such as physical alteration, permits, etc. There's a good deal of misunderstanding, and the town will not be able to enforce its most straightforward regulations unless we are represented by articulate, capable counsel, because that is what we see across the table in these conversations. Very experienced environmental lawyer representing her client with a great deal of zeal, as is required. So there are several names that have been brought forward from different circles. One of them is William Harsh, who at one time was, a brief time, was solicitor for the town of Tiverton, a former director of the DEM, and the town council did authorize him to represent the town in the appeal of the McInnes matter. And as of yet, we have not really needed his services. We paid one bill because he read the file. We owed him for that. Another name is been brought forward by different people in the community is Brian Wagner, who's an attorney, was at one time, I believe, deputy legal counsel for the Rhode Island Department of Environmental Management, and is recommended by Save the Bay and other environmental agencies. The last recommendation is attorney Chris DeVideo, who was also a DEM employee for a long time. He worked in the septic system compliance division and has a background in soil testing and septic design, and then went to law school and is now an environmental lawyer in private practice. Those are the three names that I would put forward. I think we need to get somebody very quickly because there are things that we need to do to defend the town's position. The vast majority of what we're trying to do here is negotiate and try to get compliance without having to go to court. But if we can't, then we need the very best legal counsel. And we also need to not be afraid, frankly, to elevate matters when it's necessary to the Superior Court for either declaratory judgment or injunctive relief for the town if we think it's necessary.
Madam President?
Yes.
I just want to be on record being an objection to this. It's my personal opinion that if we were working with this business to ease the zoning out there, that we would not lead to have legal action. We should be working with this business, not dragging them into court, trying to shut them down.
Well, I think that's a little bit unfair. It's not just.
I don't think it's unfair. I think we see it across the town where we're dealing with non-conforming. We made them a non-conforming use, and now we're trying to put them out of business with the different zoning regulations that we feel are not being complied with. These businesses provide jobs in this town. They're keeping Four Corners historic. Okay? They have to have money to put into those buildings, to put the roofs and the siding on. And when you're going after these businesses like we are, instead of working with them to help end the zoning issues out there, to make them conforming uses so that they can expand in a way that's not so large that it ruins the historic value out there. I worked in Newport for 25 years. I see how it works. I see how Newport is known nationwide. And everybody said things like Long Wharf and Bowman's Wharf, you know, when he built all those buildings, we're going to ruin the city. You know, there were a few that said that, but look what we have in Newport. It's the jewel of the state, and it's known nationwide. We could simulate that here with the businesses in Four Corners on a smaller scale if we worked with them instead of dragging them into court and trying to shut them down.
I don't even know what to say to that. Peter, would you like to say something?
I would like to make a motion that we go forward with the special counsel, but I would like to have another, to the next town, I'd like some more choices of
Well,
attorneys.
like
I
to-
would have
you'd
no
like
problem
more
going
choices?
forward with the special counsel, but next town council meeting, maybe choose the attorney or the council. I make a motion that we go forward and appoint a special counsel for the Four Corners. But these three names were just given to us, and I think I would like to do a little bit more research and maybe have some more names thrown out as suggested for the next town council meeting.
Yeah, I disagree, Peter. Historically, what we've done is been presented brief biographies, or reached out to them, presented with a quick biography, you know, CV, and a proposal for fee structure and you know, some amount of diligence. They all, I mean, I'm not gonna say they all sound great, but they all sound competent. I don't know any of them very well, and I would like to know a little bit more about them so I can make a informed decision going forward. And it would be nice to understand their fee structure and some brief thoughts. It would also be helpful to, we've reached out to these people or in advance to make sure that they are keen on taking the assignment, etc. And you don't have to take them, but I took the liberty of calling a friend who works in Massachusetts who does similar work, and she gave me 2 names in Rhode Island, so I can forward you those just for belt and suspenders approach.
So I'll put this back in the agenda in 2 weeks. If, Matt, you could approach the 3 that you've suggested to see if they'd be interested, their schedule fees, and maybe a small resume. Brett will give those 2 names, and Peter, in your research, if you find any, if you want to submit them to Matt also. Does that sound fair to everybody?
Madam President, at this time, yeah, I'm looking at the rest of the agenda, and I'm looking at the time we have. We're never going to get through this unless you want to be here till about 1 o'clock in the morning, and I don't. So I would make a recommendation that we continue this meeting to next Monday.
Second.
And continue it with the fees resolution for the fees and fines. We have to get that done, and the rest of whatever's left on this agenda. After 4 hours, my brain
I
is
like
fried.
some discussion from the council.
Yeah, might I just plead with the council, my item will take between 10 and 15 minutes, and I am on vacation till Wednesday of next week.
That's fine.
So it would be G5, so that we would continue everything, but is that including executive, though? There may
Including executive, yeah.
Is there any executive session that we need to have tonight? No? Okay.
No. Madam President, G3 and 4 are time sensitive for me. I don't know that there's a lot to talk about, at least for G4. Because you've already authorized me to sign the letter of intent, and this contract is the legalese that went behind all the terms that you've already approved. They're waiting for the execution of that contract.
You know what? I don't have to work tomorrow, so I can stay until 1 o'clock in the morning if you'd like. So I'll remove my recommendation.
Well, no, Matt, which one did you say was important? Both of them, G3, 3 and 4?
Yeah, I guess all the comments that have just been made is to finish new business and then call it quits. But I've got firefighters considering offers from other communities.
Okay.
And I would like to have that MOA to at least offer them the opportunity to stay here. On the cell tower lease, I actually think this is, I hate to use the word formality, but you've already approved all the economic terms in the agreement. I reviewed the agreement and they are all in place. And then Councilor Pelletier made his request for item 5.
I'll make a motion to continue. I mean, we don't need a motion, just continue.
No.
We'll stop when we want.
Wait 1 second. Could we, well, when we get to executive, we'll put it, so not even have a meeting next Monday then? Because it is getting late, and I'm not really.
I've got no problem staying. I'm just thinking of the rest of you.
What?
We only have this building till 11.
We only have this building till 11. Okay, so that kind of. All right, let's see what we can get through until 11. Okay. So, but I am. Motion's withdrawn right this moment. G3, Town Administrator ratification of recruiting and retention MOA with IAFF.
Madam
Seems
President.
like this could be long.
Yeah, Madam President, it's a recommendation from the Recruiting and Retention Committee that's been working with the fire department to come up with a counteroffer, if you will, to compete for the services of 4 firefighters who may leave us in the near future. We have just begun to turn the corner on being fully staffed at the fire department. The conversation with those 4 employees through their union president resulted in this draft memorandum of agreement that is in front of you. We would advance those firefighters to first-class pay in exchange for an agreement that if they do not stay for the period of time that they're advanced, that they would return the money to us that we had advanced them. This is not, we're not talking a long-term indentured servitude here. We're talking about a year at most. And you'll see the fiscal impact of the decision was attached for your review. And even if all 4 went for this, we would still have, it would be about $17,000. Upon information and belief, I think we're really talking about 2 that are likely to accept this agreement. But just remember that when we are not fully staffed, the machine that creates overtime cranks up to a very high level of activity, and it'd be much more expensive. We're looking to stabilize this group and compete for them. A couple of them are paramedics. We'd like to have them stay.
I just wonder the precedents. So these people are saying that they're going to leave, so we're going to offer them more money, but no one else in the department. So suppose 2 other men say this is a way to get a raise. Like, I'm wondering, do you know what I'm saying, Matt?
I happen to agree completely with that as the most likely downside of proceeding this way. But I believe that the Recruiting and Retention Committee, it's unfortunate that the chief isn't here. I know Linda's here and attended those meetings, if you want to speak up to it. But we feel like we have to compete right now for these men right now, based on the qualifications that they have, and their reasons for leaving are not, they're purely economic. They're not unhappy with the department. They love the training. They love working here. And in some cases, they labored through 2 years of probationary pay and then fourth-class pay that we eventually did away with in the contract. And now we're trying to catch them up. The agreement specifically lays out in the boilerplate that Mr. Cavazza supplied us with that this agreement doesn't set a precedent between the parties. It represents a one-time move to try to hold on to a couple of valued employees.
Do we have any idea in round numbers what it would cost to lose these guys?
I appreciate the question. It's a good question. Unfortunately, I would have to be able to predict what the impact in overtime in a 56-hour work week, but I think it would be considerable, because once we get to the new year, the new contract year being July 1, we'll be operating under the cap. So we'll be paying straight overtime. We won't be subject to strict FLSA until after they've breached the cap. And we are going into the most heavy vacation period on their schedule. So it's, we're trying to let the guys take their vacation, the more senior guys claim it. And we already have rules in place to prevent too many of them from taking vacation. But if we are already short on a shift and we have men who have already bid their vacation time, what we're going to start doing? Mandatory callbacks. We're going to start doing mandatory callbacks on 24-hour shifts. We'll have guys working 72 hours.
Madam President?
Yes, go ahead.
In this MOA, it says the town agrees to promote the employee from their current rank to the rank of first-class firefighter. Have they completed all necessary requirements to go to that next rank?
Madam Vice President, thank you for the question. These ranks are pay steps and don't involve qualifications.
Thank you.
Anyone else?
I got it. Madam President, I agree with this. I was actually partly involved in this process, and I agree with it. The only thing that gives me a little bit of, as they say, agita, is that are we going to see the police department in front of us in 4 months?
Yeah.
Are we going to see the firemen come back next year with another list of people that are going to be up to grade 1? It's just, we can say it's a one-time deal, but is it a one-time deal? I understand the whole process. It's a lot cheaper than training people. It's a motivator to keep these people here. I understand all of that. My only concern is what's going to happen after.
Linda, did you want to speak?
Just sitting on the retention committee and meeting with the chief and the captains. They've accepted this as a one-time deal. We're looking at 2 of the 4. One of them is a few months away from a first class, so we're talking it's like 60 or 70 days from his anniversary date. Maybe it's a little more. I wish I had my notes, and I certainly wish the chief was here this evening. We did go through, and we didn't calculate the overtime number, but we certainly talked about not only overtime, summer schedule, possibly losing 2 of the 4 that was being considered for this, as well as the equipment. When a new person comes on, I couldn't believe it myself. You look in a closet, and all their equipment is per their height, weight, so forth and so on, so you can't necessarily transfer equipment.
I can't assess, precedent be set, but I can certainly tell you that by not, taking a look at it or considering it, the implications is certainly great.
So I just add the flavor, since I keep a chart of where all of these firefighters are in their seniority progression, and I update it from time to time. The two that we believe are most likely to go forward with this agreement, they signed up with the town in the beginning of July. That's their anniversary date. So we're advancing them 1 full year. So they should be second class for the next year. We'd be advancing them up to first class. If they were to leave us before they actually matriculate into first class pay, they'd owe us the difference that was paid them. We can't require them to stay because, as Attorney Cavazza advises, that would violate the U.S. Constitution.
And two of the four, the discussion was most likely they wouldn't sign it because they wouldn't want to be in the position to return that amount of money. And the two that were willing to sign on the dotted line, they are willing to say, I am committed, I want to stay here, and if for some reason I do go, you get your money back.
And I agree with Ms. Lawson also. I mean, again, I'm on the same committee that she's on, and she's correct. I believe, actually, that one of these gentlemen are on somebody's list. I think it's Portsmouth's. And he said he wouldn't go to Portsmouth if this happened, which is great. My only concern, again, is that...
He's setting a precedent.
Yeah, and you know what? If it's going to save us money, maybe this is the way to go.
Does the rest of the union know about this, or they don't need to?
These representations were made to the town by the president of the union.
But does his union members know that?
I'm going to give you the old school answer, which is if the president tells me, I have to assume that his body supports it.
They do. Yes,
If I
Joe.
could, please. Only to say that in the past, there's been special deals that have come back to bite us. I mean, and I think this does set a precedent, and I think we will have more employees come before us saying that. And quite frankly, I think we pay well. I mean, we might not pay as high in the state, but we do pay well. And I prefer to have employees that want to stay in this town that are not going to hold us hostage every couple of years because they're not getting enough money. So, we need to work on our recruitment and retention, but making special deals is not the way to do it.
Any other comments? I'd like to entertain a motion.
Madam President, I move that we ratify the recruiting and retention MOA with IAF per G3 attached.
Do I have a second? Dave. Any further discussion? Motion's been made in second. All those in favor? Against? 6-1 Nancy. Joe's no. Do we really have to be out of here by 11? So we have to be out of here by 11. They lock up. Town. Okay, but that's overtime for the custodian. Town administrator, final ratification of Crown Castle cell tower lease.
Madam President, I'll be very quick because I've already talked about it. This is the legal embodiment of the letter offering economic terms to the town to renew that cell tower lease. They were offering us no signing bonus. After negotiation, they went to $10,000. They also increased the rent. And importantly for many, there is a option in this agreement that is very much in keeping with the town's vote at FTR, namely that a right of first refusal must be extended to Crown Castle if the underlying lot where the DPW and police station are located would be sold. Crown Castle would have the option to buy that piece of land outright and have that tower right in the middle of it. So I think those two, the resolution goes hand in hand with agreeing to this fundamental lease agreement.
Any questions from the council? Like to entertain a motion?
Madam President, I move for the final ratification of the Crown Castle Cell Tower lease and authorize the town administrator to assign the document attached to G4.
Motion's been made and second. Any further discussion? All those in favor? Unanimous. Councilor Brett Pelletier, Seaside Gas Station and Stonebridge Abutment. Discussion on construction, project engineering, legal arrangements, funding mechanism, and project administration oversight.
Yes, thank you very much. Very briefly, I think it's prudent to discuss most of the meat and potatoes of this at a special meeting in the coming weeks. I don't know if you want to schedule that now or poll the council via email. That's fine with me. But I did want to get a quick update and give a quick update. I know we were waiting on some information from DOT that was supposed to come today. I spoke to Senator Pagliarini about that this morning. I think, Peter, you were talking to Jay Edwards. We were kind of trying to cover everybody to make sure we had follow through. But did we receive, I didn't receive anything, but did we receive anything from DOT today?
Matt, Jay just indicated to me we did we?
Yes, so he handed it to me during the break.
Oh, okay.
Yeah. I have to cogitate on what it said in that letter.
Okay. This is very...
In other words, it's not a detailed breakdown. It's a final number. So now I have to go back and ask the same person who did that, how did you arrive at that number?
Yeah, I guess we can talk about the accounting at that special meeting. That's less important than from today forward. So I know we have a fairly short window for advertising and permitting and things if we want to optimize our chances of getting a competent contractor to do the improvements. I guess I wanted to focus on a couple of things, that being our window. Also, the amount of, and this is sort of a political thing, but it's important, the amount of leverage we have for the Stone Bridge project with the state, I think dries up in November once the casino referendum is on the ballot. So I think we have, if there is any leverage we have with them, I know we are actively working with them for a zoning overlay and a comprehensive plan and some permitting things, trying to fast track those things. To the extent we can turn that into some, whether it's a spotlight on the deal we're doing with Stone Bridge, or if it's just incentive for them to kind of step up to the plate and deal with this in a little bit more professional manner, I think that we ought to avail ourselves of those potential negotiation points. And, go ahead.
No, it's okay. Go ahead.
So I guess all of that goes to say, what's our plan going forward? Who is going to be in control of the project? I think, depending on what the DOT information looks like, I think we have to make some decisions, because, it feels like, for me anyway, that we have had far too much reliance on VHB to kind of point us in the right direction. They are, while they've been good and their designs are good and I think their work is fine, I worry that they're too friendly with the state. That's their bread and butter. They're not worried about losing us as a customer. They're worried about losing the state as a customer. So to the extent we can sort of bring the project control back into the town's control, I think it also saves us some money having DOT do it. That $100,000 can go towards some improvements rather than paying DOT staffers to administer a project. I think we can probably do in-house. And to wrap it up with a comprehensive conversation with CRMC, because I think they're the lone wolf on this. They're the wild card. We don't necessarily have any direct input from them thus far. We've got sort of a game of telephone between VHB and the people at CRMC, and I think we're this late in the game, we need to get this all together at once and really have a strong plan to hit our milestones. I think we've run out of excuses of DOT's doing it, or it's waiting for funding or waiting for approval or something. We got to just do this thing, for lack of a better phrase. So, a lot of that lands on you, Matt. I know you've provided a tremendous amount of documentation, and I think that's a good start for that conversation at our special meeting. But I think we've got, what is our deadline? I know someone said something about August, a soft deadline for advertising and construction, but what's the next steps, and what are we doing to get this back under our comfort zone?
Madam President, I think that we operate under the understanding that the CRMC window is around 6 months, and we want to get the permitting done as soon as possible. I'm going to tell you something. What I've learned now from reading almost 2,000 pages worth of documents, when I'm not chasing friolators, that's what I do. Serious work for the town, multi-million-dollar projects and considerations with many different legal issues. That's what I really do. And I fixed the friolator thing this morning, by the way. So what I have found is that years would go by, and it actually got to be a running joke with VHB, because they would write to the town administrator and say, 3 town administrators ago, I asked for something. And we're not in that status right now. We're in a position where we can get them to do what they're supposed to do, and they're also under the gun from the state. What I would think we need to do is get specific approval and direction from the town council. I need to go into that CRMC meeting or any conversation with anybody with the firm conviction that the town's elected leadership supports the design, is comfortable with the budget and the timeline. And that's all the information anybody in my position or the town planner's position would need to know in order to pursue the project to its execution in the time frame discussed. What we can't do is kick it around for too long. So I really like the idea of a special meeting. Let's hash it all out. Let's take those 2,000 pages of documents, reduce it to maybe 2 pages in about 20 minutes of history, and then review this document that DOT finally provided, which in my mind is mostly very good news, and proceed from that basis going forward.
But that's the key here, is we need to know how much money we have before we
Right, so
can.
I want to verify what they're
But
telling
what
us
did they
here.
just tell you?
What they're telling us, now I'll read it. This is David Fish, the acting chief of infrastructure and the chief engineer at the RIDOT. As you know, the federal government awarded earmarks totaling, and this is what I don't understand, I don't know how to get this number, totaling $468,973 for this project. In 2011, at the request of the town, the State Planning Council approved the transfer of $2.33 million of authority from Main Road project to the Old Stonebridge Causeway project. I'm going to skip to the important part. The $468,973 in federal funds were obligated for design because the design was ready to proceed. Federal funds are not released until a project is ready. So therefore, that $468,973 was released for design because design was ready. The $2.33 million of federal funding under the Transportation Alternatives Program will be obligated once the project is ready to be advertised for construction. In other words, what Mr. Fish is finally acquiescing to is he doesn't have 1.7, he doesn't have 2.1, he's got 2.33, and I would assume anything that's left of the $468,973.
So, Matt, I know Whip Edwards was here earlier. Did he have any information on any of this money situation?
So was it, what did you just say? The last figure was 2.3?
Is it 2.3 again?
2.33. So where the confusion was, is we had an official at RIDOT saying that they were scoring certain expenses from the past against that 2.33. But that's not true. So the 2.33 is entirely there. And then what is a miasma of really bad paperwork on the federal earmarks, we know we have a lot more than 100,000 that was originally awarded in 2004. And the confusion still exists in my mind is what source of funds was used for the Seaside gas purchase and how much of the Kennedy earmark might still be remaining, and this mystery pot of money that keeps showing up. The money they found on February 24th, 2014 and told the town council of Tiverton, yeah, we got this extra 200, that's the 200 we're going to use. But it doesn't look like they ever used that in the purchase of Seaside Gas. But what they didn't use, for sure, they did not use any of the 2.33 million for that.
Okay.
Nor did they use it for much of the abutment improvement. That was a $100,000 RIDOT access project that was entirely funded through RIDOT and administered by RIDOT. Now, I think Councilor Pelletier called that a circus or some other unflattering term for the work that was done.
It was a waste of time.
But that was the Etna Bridge project that was bid out and paid for entirely from RIDOT sources.
Yeah, so all of that is good, and I think all of that's worth
Fleshing out
at that meeting. But I think from the basis that we stand, we have a contract with the state of Rhode Island that clearly awards us 2.33 million, 2.6 and change if you add in the 204,000 that was supposed to get funneled down to the Seaside Gas. That should be the basis of our conversation with these folks, and I think at $2.33 million, we have, and if that's good news. But I think we need to work pretty hard and pretty quickly to bring this thing back. I can tell you right now, there is no way I will be willing to hand this thing over to DOT after the cacophony of errors that have plagued this thing. So we need to figure out a way we're going to staff this thing, get it project managed, get some engineering that isn't beholden to the state, and so we can secure our own interests and move on pretty quickly.
Yeah. For the record, is that the town treasurer still here?
That looks like her shadow.
Virtually every single aspect of the accounting that was handled by the town of Tiverton foots to the penny. The town knows exactly what it has done. It's the state. When you ask them, it's like they're pulling rabbits out of the abyss to try to answer your question, and they never answer it directly.
Yeah,
this is probably the best answer we've gotten.
And these emails are interesting to read, because there's also this at the state of answering exactly the question they are asked, and it really is annoying because there's plenty of emails where it's a little vague and it's, well, how much money do we have left in the account? And they say, the specific account has $100,000 left in it, period. It's frustrating. So that can all be discussed at a later date, but
I'm off. Are you available next Thursday or no?
let me check.
I don't remember when you're coming home on Wednesday.
On Wednesday.
Is everyone available next Thursday? So
No,
Yes.
I'm sorry, I can't.
No, you
I
can't.
have-
I would like to make a comment though, too.
Yep,
I
when
just-
you're done.
I am available on Wednesday night, but I am not available on Thursday.
Do you really want it?
I cannot move the thing on Thursday, I'm sorry.
The only reason why I said Thursday is I didn't know if you wanted to have a meeting the minute you got home. That's why.
I will, no,
Because you're getting home on the 22nd.
no, actually, I get home late on the Tuesday.
Okay.
Very late, but Wednesday is, I'll be home.
Is everyone available? And I will let you speak, Peter, but June 22nd. Just so, because we have to move this forward. So June, I am. Joe, are you available June 22nd?
It's Wednesday.
Joe Souza?
I'm pretty much available any day.
All right. Dave? Peter? Jay? Joan?
Okay for June 22nd.
All right, June 22nd at 7 o'clock. Special meeting, and this will be the only thing on the agenda. so that we have plenty of time and we don't
Town
have.
hall's available?
If not, we'll find an alternative. We maybe could do it here, or we could do it at the library. We'll figure it out.
Yep.
All right, the maintenance people are walking by, so.
I'll move that we continue this matter until...
I would like to make one
Oh,
more
sorry.
comment.
Yeah, please do.
So Matt, when you started saying that I couldn't add math that meeting, I guess I knew how to add math. I want to make a point, Matt, that you knew these figures. You had these figures all this time, yet you, whatever you decided to do and not give us these figures, we'll continue that at the next meeting as well.
No, we won't.
Yes, we will.
No, we
No,
won't.
well,
Yes, we will,
No,
because you handed over
wait
to
a minute,
Matt,
wait a minute.
you handed over to Brett just this week a package that this town had those figures for.
No.
Since
What
you became the
happened,
town
what
administrator.
happened was, after the town council asked me to look into it,
I asked you to, I was looking into this for a
What I did
while,
was-
and you kept on telling me that I couldn't add
what I
math.
did was, I went
So
back
I'm
through
going to
all
make
of the
my
records.
comment, Matt. I don't think you were honest with me and the town, and we can finish this later.
No.
Because we're going to get the
No.
figures, because you
No, you
had
don't get to do
figures to
that.
Brett. You
All
gave
right, this has
figures
been a
to
long
Brett
night.
just the other day that the town had since day one.
No.
The math was very simple.
No, it wasn't.
Yes, it
And it
was.
still isn't. And what I did was, I
don't think
responded
so.
to the council's desire for a deeper inquiry into all of this. I pulled up all of the paperwork,
My opinion,
read
Matt.
as much as I could, and I continue to document as best I can what the scenario is. And I have already signaled that I'm still going to do additional research into the letter from RIDOT to make sure I believe the numbers they've presented. But as I let the record show, that I used email to apologize to Councilor Mello that he was offended after the last council meeting. And so I'm not going to take that tone of voice, but what I can't let you do is package me as somehow being deceitful. There's a lot of information here that needs to be sorted through, and unfortunately, a lot of our record keeping wasn't as detailed or as specific as it could have been to make this entire analysis. Ask yourself that question. How did we get to 14 years into this project and we can't answer simple questions? Because nobody did the work. So now, 14 years later, we're trying to do that, penny for penny, dollar for dollar. And on the town side, we're perfect. But then we ask the people who have the answers where their documentation is, and they don't give you straight answers. And in that environment, you just have to keep working hard until you believe what they tell you.
My opinion, Matt, and I'll never change that opinion.
Motion to
All right,
adjourn.
well, wait a minute. You just can't do a motion to
We
adjourn.
need to continue this matter.
Right, go
Can you
ahead, Brett.
please- Can you withdraw the motion so I can please put this on for the special?
What motion?
You made a motion to adjourn.
No
Made a
one
motion.
seconded it.
Yes,
Yeah,
Joe
somebody
did
did.
immediately after.
I didn't hear him. Could you withdraw the motion just for a
I'll
minute?
withdraw the
'Cause I got
motion
some
from Mr.
housekeeping.
I just want to make a motion to continue the Seaside Gas and Stowbridge abutment discussion until a special meeting on June 22nd.
Second.
Thank you.
Motion been made and second. All those in favor. Now, wait a minute. There has to be another motion to continue the rest of this
I
agenda.
move that we continue the rest of the agenda
Until the next
to our
scheduled
next
meeting.
regularly scheduled meeting.
Second.
Motion's been made and second. All those in favor. Now you can make your motion, Dave, to adjourn.
Motion to adjourn.
Motion been made. All those in favor?
Aye.
Aye, aye, aye.